All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, Griffin, and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, and welcome to the Tuesday, January 14th, 2025, sitting of the Massachusetts Appeals Court. My name is Marguerite Grant, and to my right is Judge Robert Brennan. To my left is Judge Robert Toone. We will be the panel for the 5 remaining cases we have on today. We have already heard one case on Zoom. We will probably take a break in between the third and fourth cases, which in the courtroom will be the second and third cases. No, yeah, second and third. So without further, as some of you in the courtroom are experienced appellate litigators before us, some of you maybe have not been here before, so I will tell you, each side has 15 minutes to argue. Please speak directly into the microphone and keep your voice up in your closing argument voice. There is no rebuttal, so when there are a minute and 30 seconds left to go, the green light in front of you will turn to yellow, and that means it's time to wind up your argument, make your last few points that you don't want to forget. You do not have to use all of your time. You should know that we are very familiar with all of the briefs and materials that you have filed, so you might want to jump right to the heart of your issues. With that, I will call the first case, 2024 P267, LYNN ALLEGAERT versus members of the Edgartown Zoning Board of Appeals and another.
Good morning, Justices. My name is Dan Larkosh, and I'm here on behalf of LYNN ALLEGAERT to present her appeal. She has been named a defendant in an abuse of process case filed by the Harborview in alleging that she has made numerous cases over the last 4 years. But I do want to jump, as suggested, right into the heart of the matter and state, first of all, that this is a appeal from the denial of a slap suit motion to dismiss, where the judge and the Harborview agree that the first prong of the test is satisfied, that my client is being sued for her petitioning activity. Therefore, the burden shifts to the Harborview to show that my client's petitioning activity is devoid of any reasonable factual support or any arguable basis in law. Now, it's not clear in the court's decision whether or not it is clear in the complaint that the complaint is being made to address lawsuits other than the lawsuit that was brought to appeal the most recent relocation of the Pease Cottage. But these cases have already been examined, prior cases, by the appellate court in Algart versus Harborview Owner LLC, 100 Mass App Court 483. And the presumptive viability of those prior cases has already been determined. So it can't be any more clear in that case, in those cases, that those cases are not devoid of any reasonable factual support.
Well, the counterclaims refer to the lawsuit, right? So I'm assuming that when we look at the basis for the counterclaims, we have to limit our focus to the claims that your client made in the present action. Don't you think that's true, instead of looking at past litigation?
I would say that that's the proper analysis, Justice, that we should focus only on the present case and not be focusing on the others. However, I'm not so certain that's what the court did.
Okay. Well, so Oh, you don't, you think, the court, because the court went back and sort of reviewed the history and sort of made a judgment based on that, okay.
Correct, and said that the holistic view of the pleadings
Right.
talked about things in broad strokes, which seemed to indicate that this, and the complaint itself, the opposition, the argument made by the Harbor Review, all references this 4 cases in 4 years, 2 of which I believe are going to trial this spring. And as I said, the presumptive viability of those cases has already been ruled favorably in favor of ALLEGAERT. And that has curb appeal because, hey, what is this woman doing clogging up our court system with all these cases? But simply because my clients filed a number of cases that have not yet gone to resolution doesn't mean that those cases aren't reasonable or don't have reasonable factual support.
Okay, well, let's assume we have to limit our focus to the claims actually made by your client in
Yes,
her
Your Honor.
complaint, and there's 5 of them, and because the counterclaims talk about the lawsuit, I assume that we would, for the counterclaims to have any validity, we'd have to find, or there'd have to be a basis to conclude that none of the claims that she is asserting have any basis in law or fact.
Correct, Your Honor.
Okay. So what's your
None of the
position?
claims she's asserting in this present case have any reasonable basis. That would be the Harbor View's burden.
So what's your best argument then that
Our
of
best
the claims that
argument
she's
is the
asserted
zone.
that's you can't make that finding based on the
Our
5?
best argument is the zoning appeal.
Okay.
And the zoning appeal, the issue of standing was never raised in the lower court in any respect by the Harbor View. That's a new issue that's just been raised on appeal, and the Superior Court never ruled on that issue of standing. The Harbor View's brief and its argument and the decision argues or finds that the matter is devoid of factual support because it's in essence an omnibus appeal of the 2008 and 2018 approvals of the Pease Cottage. And back in 2008, when the Pease Cottage was first being sought by the predecessor in title, the Harbor View, or Scout, the predecessor, went before the commission, and the commission ruled favorably and upheld the privacy rights and the screening issues that ALLEGAERT had raised. And the matter went before the zoning board in Edgartown, and the zoning board upheld my client's privacy rights. They upheld the screening rights in the initial decision. That was upheld. And the commission's decision was even incorporated into that initial approval of the Pease Cottage.
And your client wasn't opposed to the Pease Cottage at that time?
Never
right?
been opposed.
So I guess this raises, because I look at the claim, your zoning claim, and at paragraph 16, it states, it alleges, the plaintiff is particularly aggrieved by the addition of the new 8,780 square feet Pease Cottage structure located in close proximity to her home.
Right.
So it seems like she is switching positions she's now opposed to the Pease Cottage when in the past she wasn't. I don't quite understand what you're doing here with
Yes.
respect to that part of the zoning board claim.
Great question. So she's not opposed to the Pease Cottage. She's never been opposed to the Pease Cottage. She supported it in 2008, supported it in 2018. Both times the Edgartown Zoning Board said she had rights to screening, said she had rights to privacy, okay? Really what's happening here is in 2023, we had this incident in 2019 where all her screening was removed, the screening that was supposed to be protecting her property, and then it was put back, but it was inadequate. And so then they came before the board, the Harbor View came before the board. First they went before the commission, and then they sued the commission and settled with the commission. But then they went back before the zoning board and moved to relocate the Pease Cottage. So Mr. O'Flaherty will point out that the cottage is actually being moved away from my client's home. However, it's being moved off the Great Lawn, and it's being moved further back where the balconies now have a better view of my client's home. And if you look at the record appendix at 369, Mr. Janae has taken a picture of the screening from the Great Lawn, and you can see my client's home. So my client's argument is really, they removed the old screening, they put back screening, it's inadequate, now it's being moved, the Great Lawn is being opened up. Okay, this is cumulative. We're talking about the pool bar, but we're not, that's a separate case.
I'm not sure it has a whole lot to do with how we decide, but I'm just curious. When you say the screening is inadequate, is it young trees? Is it short trees, different types of trees?
Right. Yes, there are arborvitaes, they've been planted, there have been a couple of rows, but the screening that existed, that was torn down, was much more dense and bushy and had been there for 20 years or more.
So that's my question, is in 5
Yes.
years, might the screening be adequate, or in 10 years, and they just planted less mature plants, or?
Who knows?
All right. Yeah, they said it.
They might get torn down again unless we have some zoning protection that protects us, and that's really what we're seeking, is to
I guess
make
my
certain.
question is, no matter where it goes at this juncture, if you put in new trees, unless you are able to plant fully mature trees, how's that working? I don't see that they can.
I agree.
Pop in a forest.
I agree, Justice. The prior decisions called for a landscaping plan to be submitted. Right. The landscaping plan never materialized. And in 2023, the zoning board adopted or referenced the prior decision, but also referenced a more current decision that was a settlement that was reached between the Harborview and the Commission in their case, and referenced that and said that that would be operative now. And so it seems like the prior protections that were upheld were abandoned. And this needs to be clarified. And also, there is no book or page reference to this commission decision. This commission decision, I was able to find it on the Vineyard Gazette website and nowhere else. But it does reference, again, screening for my client. It upholds her right to privacy. So there's no issue with respect to standing. My client has standing. She's a direct abutter, and these issues have been upheld, and the Harborview's never appealed those rulings.
That's a different question. So
Sure.
you led with claim one, but claim one by your client is against the municipal defendants, right? It's an appeal of a zoning board appeal. The hotel isn't really subject to that claim.
Well, they are named. They're named, but the whole thing is we're being sued because we appealed.
Oh, wait a minute. They're not named in that claim. The claim, count one, says appeal of zoning board appeals decision. We don't normally include private parties as defendants if you're bringing a challenge to a zoning board of appeal decision. Claims 2, 3, 4, and 5 specify that they're against Harborview.
We're being sued. There's no harm that results from the other cases. The harm that the Harborview is alleging is because of our zoning appeal, and that by operation of 40A Section 17, that it operates like an injunction, and that they can't build their Pease cottage because.
But if I make a counterclaim for abuse of process to a multi-claim complaint, is it reasonable to assume that I'm complaining about all the claims, even those that aren't against me, or am I making an abusive process to the claims that are against me?
If one looks at the record, the Harborview is particularly concerned with the zoning appeal, and my client is being sued because she made a zoning appeal seeking exactly what she's looking for, which is to protect her rights to screening. There's no ulterior motive. There's no ulterior purpose. And it has a reasonable factual basis, and there is a good legal basis for the zoning appeal, and that's why she's being sued, because that's the only aspect of the case where the Harborview says, hey, this is preventing us from building our Pease cottage because the zoning appeal acts like an injunction. which is a generic allegation that could be made in any zoning case. You can always say, hey, you sued us under the Zoning Act. That prevents us from doing our development. It's completely generic and not specific to the petitioning activity of the petitioners. All my clients...
So just assume for the moment that you had to defend, you wanted to obtain an anti-SLAPP dismissal of the counterclaims based on the claims that against your client, 2, 3, 4, and 5. So what would your argument be with respect to that?
Okay, so with respect
Contract claims and emotional distress and nuisance, right?
With respect to those claims, my client did have a contract with the predecessor in title, a Scout. It says it applies to the successors. There's been conduct between the parties that's part of the record where the screening was torn out and then Mr. Chu, the owner, agreed to put it back. And my client, there's a letter in there, the file, she's undergoing therapy. They dumped dirt on her fence, that would be a nuisance. So there's reasonable factual support for these other causes of action, but the flagship is really the zoning appeal.
Do you have a reasonable support for your contract claims against Harborview, even though Harborview is not a
Yes,
party
it does.
to the
The contract does state that it bears on the successors, which the Harborview is taking, admits it takes all the benefit from that agreement. They've taken all the benefit from that agreement. So under principles of equity, even if there is no contract, we should be entitled to relief because my client relied on that agreement. The parties performed based on promises that screening was going to be put in place, and my client continued to support the project in 2018, wrote letters to the board to support that project.
So you have an argument that Harborview remains a party to the contract, or either as a successor, it's bound, or has
ratified it in some sense.
Equitable argument that it is subject to those commitments.
Correct. Those other causes of action, yes, but I would concede that they're not as strong as the zoning appeal, which has every reasonable factual support and legal basis as well, Your Honor.
All right, thank you.
Okay, I see I'm out of time. Thank you.
Good morning, Your Honors.
Morning.
Kevin O'Flaherty for the Harborview Owner, LLC. May it please the Court. Just a couple of things. I want to address questions that you raised, Justice Toone. With regard to count one, 4817, the Zoning Act, requires that the plaintiffs name the municipal board and the permit holder. That's us. So that claim is against us for sure. And if you look at the complaint, Your Honor, Mr. Larkosh said they're not trying to stop the construction of the Pease Cottage. The complaint, the amended complaint and the original complaint both seek a temporary, a preliminary, and a permanent injunction against my client for constructing and operating the Pease Cottage. So that relief is directly, targeted to my client's development here. Now, let me just say...
But that seems to hurt your position in this context, right? Because you're sort of essentially saying if there's any objective basis for that ZBA, that zoning claim, then
yes.
your counterclaims should have been dismissed, right?
Yes, I'm not arguing that we're not a party to count one.
Okay.
Your Honor had a question about that. I want to be clear. I want to be straightforward with the court on that.
Yeah.
But here, let me tell you why count one has no legal force and, in fact, no factual force. Count one is a claim that essentially, as I understand it from Mr. Larkosh's papers and also from the arguments made below, that the Zoning Board of Appeal made a mistake in granting us the permit in 2023, which was really a modification of a 2018 permit. I'll get to that in a minute. But made a mistake by not including in that permit some kind of condition regarding screening, because they claim privacy is an interest within the protection of zoning. As we all know, Your Honors, Every complainant, every appellant, every plaintiff in a zoning case has a threshold burden of standing. And while Mr. Larkosh argued a second ago that that is not relevant here, standing is always relevant. The case law is absolutely apodictically certain that you can raise, your honors can raise standing at any juncture. It can be raised after a judgment has entered. Standing is an essential jurisdictional prerequisite. Number one of the first legal issues that the court has to address here is whether these plaintiffs have standing. This plaintiff doesn't have standing. Here's why. Privacy, which is the issue that Mr. Larkosh contends is the problem here, that somehow the construction of the Pease Cottage, by the way, it's completely speculative. The thing doesn't exist. So again, in standing law, you got to do more than raise conjectural speculation. But the point is, the Pease Cottage, he claims, is going to potentially interfere with the privacy of people at 14th Thayer Street, which abuts. Privacy, Your Honors, is not protected under zoning. What's protected under zoning in cases, sometimes zoning cases, 4817 and Boston zoning cases, sometimes discuss privacy, but it is a surrogate for density, always. In other words, if somebody builds too close, too tall, too big next to your house, you have an impact, there's an adverse impact on you not because of privacy. Zoning doesn't forbid people from looking from their yard into yours, especially in a context like this, since the hotel's been there since 1891. People since 1891 have been able to look across the property line into her property. Zoning doesn't protect against that. What zoning protects against is overdense development. There is no allegation in this case, and in fact, there is no, the Pease Cottage complies in every respect with zoning. It's not in the setback, it's not too tall, it's not got too big of an FAR, none of that. It's far from her, as a matter of fact. It's 50, 60 yards from the back of her house is where it's proposed. So number one, privacy is not an interest that can be protected. Therefore, you cannot base standing on an interest that zoning doesn't protect. The law is clear that the harm has to be within the scope of the statutory regime which would allegedly protect it.
I think that's an interesting point, but it gets to my fundamental question about what happened here. Your position is that the plaintiff's claims have no basis in fact or law.
That's right.
Why didn't you move to dismiss under 12B1, 12B6?
Oh,
why did you file an answer with these counterclaims?
We have a pending motion in front of the court that hasn't been scheduled for hearing for
you have
summary judgment, Your Honor, for summary judgment.
Summary judgment, right.
We went ahead and took discovery and closed out his side of the case, and that's pending. So we have done what I think we need to do. We had to file the abuse of process claim in our answer, Your Honor, to preserve that. But let me...
Well, actually, so we just held, in this case, Hidalgo.
I know
right?
that case.
You know that case. Okay,
do,
so it's
Your
not
Honor.
a very good case for your position,
Well,
unfortunately.
I think it is actually.
Oh, well, let me tell you why I think it's bad. Because
Yeah.
we held that claims for malicious prosecution, counterclaims and abuse of process are prima facie subject to dismissal under the anti-SLAPP
Ordinarily.
statute. Ordinarily. And it says that if you do have these claims, the time to bring them is after you litigate the initial claims and so you would be able to, in that case, bring these kinds
Understood.
of claims
I mean,
afterwards.
I know what
But you kind
Hidalgo
of jumped
did.
the gun, filed an answer, filed the counterclaims, and it seems to involve a level of complexity about what's going on. You're filing affidavits. We have to sort of assess evidentiary issues. It's not the right procedural posture for us to be kind of making all these determinations about the merits of the plaintiff's claims.
But that's what Bristol requires, Your Honor, number one. And number two, Hidalgo doesn't write away the cause of action of abusive process. And think about it for a second, Your Honor, from the trial court perspective, not from Your Honor's perspective, but from the trial court's perspective. You have the parties in front of you. Let's get to it. Let's have everything that's in the case litigated once. Not, we'll litigate and then come back and litigate the abusive process 2 years later. Let's go. Let's have it all done. And Hidalgo, Your Honor, I would say, has to also understand the statement in Bristol that says, look, there are two parties' rights to petition at issue here. Mr. Larkosh's client has a right to petition. which we think was abused. But we have a right to petition as well and bring an abuse of process claim. Hidalgo can't write that off the books, Your Honor. It can't dismiss the abuse of process claim as a, as a matter of law.
So let me ask you this, because
Yeah.
I think I may agree with you that as a practical matter from a trial judge's perspective, like you say, we're all there, let's go, let's figure this all out. But Hidalgo says one element of a claim is that the lawsuit was unsuccessful. So how do we know that the lawsuit is unsuccessful until the lawsuit is litigated?
Well,
And I distinguish this because while on a practical level I agree with you, I don't see how we get around what we just said.
I thought Hidalgo was on a much thinner record than that, Your Honor. Now, I don't know I'll confess I don't know the record. I thought Hidalgo was sort of in the posture that we're in right here, which is there was a complaint filed, there was an abuse of process counterclaim filed, and then on a very thin record, there was the Hidalgo decision. I believe here we have a much different, and Hidalgo, I know the court was careful to say ordinarily this is the way we should go. I think we're in the other camp here. This is not an ordinary what happened here. Here's why, and this gets back to why the 4817 case is legally untenable. Standing was an issue. I've talked about that. But the trial court looked at this carefully and said, this is an untimely collateral attack on special permits that were granted. Let me just narrow the court's focus onto one. So in 2018, my client became the owner of the hotel. Before that, when Scout was there, that was a different owner. We weren't party to that agreement, as Your Honor pointed out, as the trial court said. There's no privity between us and Ms. Algart in that agreement. And in
Well,
fact,
how do we know? How do we know in this record, right? That these
Because
are
the
kind
record-
of factual questions,
this
right?
is in the record, Your Honor. There are affidavits in the record. Remember now, on a motion,
Can I just say, you're asking us to kind of litigate the judgment of each of these claims asserted by the plaintiff and make a judgment that there's no merit to any of them. We have to get into standing and the complex issues in the ZBA decision. We have to sort of resolve the issue of whether the parties were privy or there's some equitable impact of the contract. These are all really complex actions, and we have to sort of say there is no merit to any of these 5 claims in
That's
order
right.
to sort of say that your counterclaims should be allowed to
Well-
proceed. That's just, it's just tremendously challenging
understood. But
project for us.
That is the standard Bristol creates. Bristol says there's 2 questions for the trial court in the first instance and for Your Honors in reviewing the trial court's decision. Was the claim, the abuse of process, based solely on the petitioning activity? Obviously. Abuse of process is that. Okay, nobody's fighting that one. But then Bristol says, but the trial court has to make an assessment of whether there is any basis in law or fact about whether there's heft, legal heft, and factual heft to the claims.
And because
to
your
do that-
counterclaims just talk about the lawsuit, right?
That's
So
right,
we
Your Honor.
have to sort of say, of all the 5 claims asserted by the plaintiff, there is no heft to any of the 5
That is
claims.
correct, and I'll get to those, I hope, those other claims. But the fact is, Your Honor, that's what Judge Buckley did below. She heard, not on the papers, Your Honor, not just on the complaint and the answer. This process goes far beyond that in a SLAPP motion, anti-SLAPP motion. There are affidavits. Mr. Janae submitted affidavits which detail the whole history. There were affidavits from the other side. There were documents. There were pictures. There were, all the decisions were in front of Judge Buckley. She looked at all that, and she determined, number one, that there was that the first count was an impermissible collateral attack on the special permits that it granted. One of Your Honors said early on, well, wasn't the Peace Cottage always part of it? And Ms. ALLEGAERT in 2 prior incarnations of the Peace Cottage didn't oppose. No, in fact, she supported it, and she supported this one in the following way. When we were before the zoning board, and it's in the record, Ms. ALLEGAERT wrote a letter. It's attached to an affidavit of mine. I think it's at Record Appendix 345, where she said, look, the things that he said, that that the Harborview, when they came in, when Mr. Chu came in and owned the hotel, he took the screening down. I think there's a dispute about that, but assume that's right. But then he replaced it with 25 tall, you've seen pictures of them, arborvitae, that then she, in this letter that she wrote to the ZBA, said, he restored the screening and I was grateful for it and thankful for it. That was in front of the ZBA. With that material, all the facts that I just described being in front of the ZBA as a matter of law, Your Honor, in a 40A17 complaint, the trial court would not be able to overturn the ZBA's decision, because in the record before the ZBA, which Judge Buckley saw, there was documentation, there were pictures, there was testimony, there was affidavits that said, and a letter from Ms. Algart that said the screening was fine. Therefore, their claim that the ZBA's decision was infirm for not requiring screening is false as a matter of fact and law.
But the problem is, as we said in Hidalgo, right, it's not the role of the court to be making these complex factual determinations based on affidavits at this stage, right? It's supposed to be a very simple procedure. Is there, on the face of each claim, is there no possible basis in law and fact? And it just, you're asking us to look at affidavits and sort of analyze this for each of these 5 claims. It seems
Your
like
Honor,
an
that's
impossible
what Bristol
challenge.
requires. That is what Bristol requires. The
Not what
second prong.
Hidalgo seems to say in this context.
Well, I think the Bristol is from the SJC, I believe, and I
Well,
believe
Hidalgo's
that's-
applying Bristol.
I understand, Your Honor, but if you read Bristol, that's what the second prong of Bristol absolutely requires the trial court to do, and I think it's Your Honor's job to look and see whether the trial court followed that. And it does talk about affidavits, it does talk about factual presentation when there is a SLAPP suit, an anti-SLAPP motion to dismiss. That is the process. Let me just get to a couple of the other part. Look, the breach of contract claim is clearly not viable. They don't even argue it, to Your Honors. They argue ratification, something that wasn't pled and wasn't preserved. Your Honors don't need to even think about that for a second, because it wasn't pled and it wasn't preserved, and as a matter of law, it doesn't apply. For ratification to happen, there has to be an agent who enters into a contract for which that agent was not authorized, and later the principal, who existed at the time of the contract, has to ratify the contract. Here, that is a impossibility, because my client did not exist at the time of the Scout agreement, at the time of the alleged agreement that's the fulcrum of their breach of contract. And they don't even argue that, Your Honor, really. They don't argue to this court the equitable claims, because where there's a contract, as Your Honors know, there can't be quasi-contractual claims. Judge Buckley got that right. And finally, on the tort claims, the nuisance, and the intentional infliction of emotional distress, Your Honor, Judge Buckley got that right. Those can't exist where the source of the alleged nuisance and infliction of emotional distress isn't built. That's a ontological impossibility. The fact is, those claims were all subject to dismissal. As she rightly found, there was no basis to them. I know I'm getting the blinking light. Do you have anything else, Your Honors?
Thank you.
All right, thanks very much.
Thank you.
So we'll hear our third case of the morning, and that is number 2024-P96, Dana R. Griffin and another versus Eric L. Miers. Morning.
Good morning, Your Honor. May it please the Court. Marwin Walters on behalf of Eric Miers, the appellant. we're here asking the court to vacate the arbitration decision below. And there are, as you know, under the statute, several grounds for that. We've proposed 3, and the main one that I'd look at today, although I'll deal with the others too as well, is that the arbitrator exceeded his authority. And we can lump what the arbitrator did into 2 categories. The first is, there's the dispute, as you know, is about an easement and the rights of the parties to use the easement and where the location of the easement was. The first thing the arbitrator did is that he eliminated a right that Mr. Miers had pursuant to the settlement agreement and the amendment of easement. And
He interpreted the settlement agreement, right?
Sorry?
He interpreted the settlement agreement. He interpreted the provision and concluded that it didn't mean that your client could park his car at night. But that seems to be different. If the test is whether he exceeded his authority, it seems like it's the authority of the arbitrator to interpret the subject agreement, the settlement agreement that's the subject of the matter, isn't it?
No,
How does that relate to him exceeding his authority?
Well, absolutely, Your Honor. That's not the case here, because the cases are very clear that an arbitrator cannot interpret a claim, or a contract rather, in such a way as to confer jurisdiction on himself. And that's what he did here. In other words, what he did is he took the plain meaning of the contract and he ignored it. So by doing so,
When you say the plain meaning, what was the plain meaning of that? I mean, you're saying you can't, I'm not sure I'm understanding you on that.
Sure. So the best place to start
7
is...
a.m. to 7 p.m., right?
Correct.
Okay.
Yeah.
And
So-
he said he extrapolated, I suppose, is what you're saying.
Well, he just ignored words. So the best place to start is with the amendment of easement in the first section, in the first line. And so we read of that, it says, notice of use, the owner of Lot B, which is Mr. Miers, shall be permitted to use the easement for parking and other uses, and I'll stop there, because a very easy
I'm
way...
sure you'd love to stop there, but it keeps going, right? It's subject to these conditions, and then what's
Right.
at issue is the
Right,
conditions that
but
are
to understand the plain meaning of the contract, we should stop there to understand it. In other words, if we put a period there, it's clear, you can ask any 10th grader in Massachusetts, at that point, does he have the right to park in the easement? And he would have answered, of course he has the right to park in the easement. The next 4 words are key, and they're completely overlooked by the arbitrator. Subject to the following. So he has the right under the document, and keep in mind, this is a real property right. The statute of frauds requires everything to be in writing, and the writing here says that he has the right to park in the easement. Then is it unfettered? Is it a complete right to park in the easement? Well, let's look. The next words, subject to the following. It then sets out the exception by which the Griffins may use the easement, and it's between the hours of 7 a.m. and 7 p.m. at night, and there's a protocol there. They actually are not allowed to use it unfettered. They've got to give 1 hour.
So you're saying that a reading of that is that they can only use it during the daytime?
No, Your Honor, and that was a mistake that Mr. Miers, he was pro se in the arbitration.
Right.
That was a mistake he made, and it's pointed out. Okay. But the mistake, they can use it subject to his right to park there. If he's not parking there, they can use it whenever
What
it's
good
available.
is a vehicle easement if a car's parked in the middle of it, right? It's not useful at all if you can't use it.
Well, so a couple of answers
I mean,
to
they're
that.
essentially, your client's essentially saying they lost their right to the easement between 7 p.m. and 7 a.m.
No, they didn't lose their right. Now, what was lost here by the arbitrator is this is not a vanilla easement. This amendment of easement is a negotiated settlement.
Right. So let's talk about that.
Yes.
Because when we talk about a covenant of good faith and fair dealing, and that's what the arbiter said, okay, that's great, you can have an easement, but I'm going to put it in a place where you can't possibly use it. Do you think that that's at least a little problematic? Or put another way, don't you think that the arbiter it's within the scope of his authority to define or to interpret that part of it?
No, Your Honor, and here's why.
Sure.
And it's a great example of how he just ignored the settlement agreement language and how he ignored the amendment of easement language. So if you look at the settlement agreement, which is volume 2, page 40, on the top, on subsection B, the parties agreed and executed this settlement agreement in writing. They've all agreed to this. It says, the entrance on Granite Street will be located so as to permit the parking of a car at the top of the current driveway. They negotiated away that portion of the property for the citing of the easement. They agreed to it. In fact, had Mr. Miers done what the arbitrator ordered him to do or said that he was in violation of the covenant of good faith and fair dealing by doing, namely moving it over where now the easement entrance is, and he should have put the way, that's not what they agreed to. So it's not a matter of bad faith, it's actually what they negotiated in the settlement agreement. But the Supreme Judicial Court has made it very clear, and Uno is a great case for that, Uber rather, is a great case where the covenant of good faith and fair dealing cannot be used to create obligations. And that's exactly what he did with respect, the arbitrator did, he created obligations.
The fundamental obligation, it seems, and that's what the arbitrator said, is to provide an access to go back and forth from the front to the back, presumably so they could put in a septic system, right?
No.
Okay.
And the reason, and the answer for that is, again, we're circling back to, this is a negotiated agreement. This is not a vanilla easement subject simply to being looked at under the law of easement, the common law of easement. It's a negotiated easement. You can't park on an easement, Your Honor. You can't do that. But under the agreement, you can. They negotiated away the right to do it, subject to a very clear protocol that between 7 a.m. and 7 p.m., the Griffins can provide notice. He has 59 minutes to move.
Why can't you park on an easement? I'm sorry, just gonna let that one go. Why can't one park on an easement? What if the easement is as wide as this courtroom and it says nothing about it? Why couldn't I put my car over there where the clerks are sitting?
Because the general common law of easements is that you have a right to pass and repass over the entire length and breadth of the easement. So if someone's parking, and there are plenty of cases that prescriptive easements are created by parking for 20 years on an easement, right? And you get that spot for yourself.
Fair enough.
So generally, but the point is that this isn't a vanilla easement. And that's what the arbitrator lost. He's a retired land court judge. And in fact, he writes in his decision, he refers to the folks as plaintiffs and defendants, not as claimants and respondents, as an arbitration decision should. But he's a judge, and he looked at it like a land court judge would. This is not a vanilla easement. They negotiated very carefully what the rights were of the parties. Now, let me talk a bit about
you said it was a recorded easement, right? The agreement was recorded at the Register of Deeds, right? So
the amendment of easement was recorded, as was the easement plan, which cited.
I would think a retired land court judge would be well suited to interpret that.
If he looked at it as, now keep in mind, his purview as an arbitrator in this is a limited arbitration provision. The reference by the court was to determine whether there were violations of the agreement, a settlement agreement, or the easement, the amendment of easement. Violations. When he used this idea that the whole point here, and I put this in my bias argument, but I also put it in terms of the exceeding his authority. When he says the whole point is to provide unrestricted access over this easement for the Griffins, that's absolutely untrue, because they negotiated away unrestricted access. They don't have the right. They don't have a right for 59 minutes every day if they give notice. They don't have a right. They don't have a right between.
So what good does it do them?
Sorry?
What good does, in your interpretation of the easement and as amended,
Yeah.
what good does it do to the Griffins?
They have access to in the morning hours from 7 in the morning to 7 and 8. They have access. All they need to do is provide notice. Then they can use it.
But they can't use it from 7 p.m. to 7 a.m.
That's correct. And the reason for that is, this is a brother and sister who have been living together next to each other rather for years. Mr.
Can I just stop you for 1 second? I'm sorry, but when you say they can use it, did I misunderstand? My memory of reading this is that they're saying they couldn't use it really because you couldn't drive a car through it because of all the rocks and the boulders and the other obstructions there.
So
that required, and the judge found that the arbitrator found that they jutted out into it, so if you can try and drive something through there, you're going to basically take out half your car.
Okay, so it's really important to understand how the easement location was determined. In the negotiation of the course of about 6 hours on the day that they were to have cross complaints of contempt with each other, the parties negotiated together. Counsel, we were both there as counsel at that time. At issue was the location of the easement, the dimensions of the easement, the turn, the radius of the turns, the entrance, all of that was at issue. If you look at the settlement agreement, it specifically delineates from a sapling to 6 inches off the house, to straight lines not closer to the water, to a radius curve, to the entrance to the left of where that, depending which way you're looking at it, to the side of where the parking lot is. They all agreed to it. They then together hired a surveyor. They both paid the surveyor. They both signed the contract with the surveyor. The surveyor, acting on both parties, surveyed the property and laid out the easement exactly as they had agreed. They then took the plan, and the Griffins had questions. They had some corrections. They wanted a wider turn. The plan was amended. They said nothing about the entrance. They said nothing about any of the locations of the easement. They had the plan. They live next door. The plan shows iron pins. The iron pins are on their property. They could measure out exactly where the entrance was. They knew exactly where everything was. They lived there. They had the plan. They signed off on the plan. The parties filed the plan at the Registry of Deeds. The statute of frauds does not allow this. The four corners of the document does not allow the arbitrator to now come in and impose something that the contract says nothing about. They could have negotiated that Mr. Miers had an obligation to fix up and maintain the easement. They did not. The SJC says covenant of good faith and fair dealing. In that case, they claimed that they had a right to purchase a condominium at a warranty of price, and the SJC said maybe they would have liked that. It's not in the agreement. You can't use the covenant of good faith and fair dealing to now impose on a party something that wasn't agreed to. The four corners of the document prohibit this arbitration decision. He has the plain meaning, again, that any 10th grader in Massachusetts could read and say he's allowed to park in that, subject to, not the other way around.
So just to get back to if we think that the agreement is ambiguous as to what happens between 7 p.m. and 7 a.m., then you don't have an argument as to the arbitrator exceeding his authority, do you? If we think it's ambiguous.
No.
Your argument depends on this being plain as day to any 10th grader, and if we don't agree with that, then you can't make an argument that he exceeded his authority. Would you agree with that?
No, he's got to find a violation. He has to file, all he's supposed to do is find a violation. He imposes an interpretive lens which is biased toward the plaintiff, saying that the only thing that matters here, the primary purpose, is the free access of everything, eliminating the rights that Mr. Miers had.
Well, can you talk about the evidence of bias? I mean, you're not really seriously asking us to accept that because they decided to finish off day 2 in his office in Danvers instead of driving into Boston from Rockport, that's bias?
No.
That's evidence of bias. All right, thank you.
No, not at
all.
all.
Right, so what is it then that in the record, what is it from which we could infer that there was any bias here as opposed to just assessing credibility as any fact finder might do?
Well, it's not about the credibility, Your Honor.
What's it about?
And the law says evident partiality means a situation in which a reasonable person would have to conclude that an arbitrator was partial to one party in the arbitration. And he writes, several times he writes in his decision, the arbitrator, as observed a number of times, supra, the primary, if not the sole purpose of the amended easement, and clear expectation of the plaintiffs, doesn't mention the defendant at all, was they be provided as owners of Lot A with freely accessible, unobstructed vehicular access to their rear yard. Those words appear nowhere in the settlement agreement. They appear nowhere in the amendment of easement. This is a real estate matter.
So maybe he's incorrect. Why is he biased?
Anybody would look at that and say he is stating the lens that he's going to look through this with is the plaintiff's lens. I don't know how Mr. Miers wins if that's the lens. I'm surprised he stopped where he did, because at one point he said, well, I can't expand the dimensions of the easement. The arbitrator said that. I don't know why. Because
Why doesn't that show that he's not biased? Well, the Griffins wanted the easement to be wider in one place, and he said, no, I can't do that.
Well, the fact that you don't give someone everything that they want doesn't mean that you're not biased. In other words,
But the fact that your client loses, does that mean he's biased?
No, the fact that he used a lens which is immaterial and has no basis in the agreements. I see.
Okay. Any questions? I do. Thank you.
Thank you.
Good morning, Your Honors. James Takulis for the Appellees, Leah and Dana Griffin. I point out to you that there was a dispute about the location and boundaries of the easement, which led to the litigation, and we resolved the litigation by entering into the settlement agreement. I point out that that settlement agreement did not establish the location of the easement because that was the reason that the surveyor was engaged. Mr. Miers wanted three things in reaching the settlement agreement. He wanted to be able to locate the easement, and he could locate the easement over the pond. There's a little pond to the west of the easement. If he wanted to build a bridge so that my clients would have access to their property, he could do that. So the location of the easement was not terribly important for the Griffins because they expected to have access. But Mr. Miers wanted to relocate the easement, and he has that right. He also wanted to be able to park at the easement. I filed a motion to strike portions of the appellant's brief because the first statement that is not supported is that Miers has a historical right to park. He doesn't have an historical right to park. He never established a historical right to park, but they rely upon that in their conclusion that the arbitrator exceeded his authority by removing his historic right to park. Well, he never had a right to park.
Can I actually just ask you to just take one step back? Because, again, Mr. Walters argued it, and it was frankly a little confused, and maybe it's I need to re-up my game to the level of a 10th grader. But it does appear that there are, in the agreement, a location. It appears to me there's a location set. There's a pine tree here, and I'm not getting exact, but you get what I'm saying. 3 inches in southwest from there, and then 2 feet in from this. It looked to me like they all got together and said, "Yep, this is where the boundaries of this easement are going to be." Did I miss that?
No, the only point in the settlement agreement that was discussed in terms of the width, and we didn't know the width at the time, was the distance from the little sapling to his porch, which was later determined to be 10.1 feet wide.
So what's the significance of that? That's what I'm talking about, the sapling to the porch. What is that?
Well, because that was the distance. If you drive through the easement, you have like 6 inches from the sapling on the left and 6 inches from the porch steps on the right. And so the idea was that whatever that distance was, and we didn't know at the time, whatever that distance was, would be run straight onto the Griffin's property and backwards towards the entrance at the curve.
So those are reference points to establish a width or a distance, not fixed points from which we're going to
It was only
locate
reference.
the...
So the surveyor went out there, oh, that distance is 10.1 feet wide, we have to make this straight line of the easement 10.1 feet wide. Well, part of the point is that, sure, the easement on paper is 10.1 feet wide, but when you go to the easement, it's 9 feet wide because there's rocks and a tree jutting into the easement. Mr. Miers also wanted to relocate the entrance of the easement. He submits that his parking is more important than access by the Griffins, which is not the law. The law is that the Griffins are the dominant estate holder, and Miers is the servient estate holder, and he has burdened his land. His land is burdened to provide the Griffins with access. So when he relocated the entrance, he did it in a fashion that it doesn't make it accessible, because what was more important to Mr. Miers was to have his parking, and he didn't really address the issue of how Griffin would access the entrance of the easement, let alone the other points of the easement, which they can't access because it's not 10.1 feet wide in accordance with the plan.
Do you agree that the settlement agreement is ambiguous as to parking between 7 p.m. and 7 a.m.?
No.
You don't. I mean, your client started off with kind of unqualified access, and then you entered in this settlement agreement, and the settlement agreement kind of asserts this right of parking subject to conditions, right? And then it kind of trails off. It establishes the condition about the hours notice between 7 a.m. and 7 p.m., and it doesn't really say anything about 7 p.m. to 7 a.m. So the arbitrator found, well, that doesn't mean that they don't have access during that time too, but it's not really explicitly stated one way or the other. So isn't that an ambiguity? I'm not saying your client loses in that case. I'm just Why is that not ambiguous?
I don't
Mr.
think
Brennan?
it's ambiguous, and the arbitrator analyzed it and didn't find that it was ambiguous. It speaks for itself. It simply says that the Miers is entitled to notice between the hours of 7 a.m. and 7 p.m. It doesn't say that he can park overnight.
It says he has a right to park subject to the following conditions,
and
right? And
there are various conditions.
And it could have said, and he may not park in the easement
Well,
between
no,
7 p.m. and 7 a.m. It didn't say that, right? That's ambiguous,
We're
isn't
in
it?
court, we're writing the agreement in the conference room, going back and forth and trying to resolve the thing.
Okay.
There was never any discussion about overnight parking, and there was testimony about overnight parking. Mr. Miers admitted to overnight parking, and the arbitrator found that overnight parking was one of the violations of the agreement, along with his violation of the covenant of good faith and fair dealing, because he has effectively denied the Griffins with access to the rear of their property by constricting the easement.
Just give me your position on the question of, let's assume that this is an ambiguity that the arbitrator had to interpret to arrive at his decision. How does that relate to the issue of whether the arbitrator exceeded his authority?
If it is in fact ambiguous, he would have authority to interpret an ambiguous provision, just like a court has authority to interpret an ambiguous provision. It's the same thing.
And then what is the role of the court then?
Even if the court thinks that the arbitrator was wrong, provided that there are no Chapter 251, Section 12 grounds, even if the arbitrator is wrong, the court must sustain the arbitrator award. So if the court would have determined, well, it's ambiguous and we'd reach a different conclusion, that's not to be done. What is to be done is to offer deference to the arbitrator's award, provided that he didn't exceed his authority, provided that the award wasn't procured by fraud, and provided that there was no evident partiality. And I submit that there is none of those things. The other allegation here is that the order of reference to arbitration was an error. And I submit that it was not an error, because the only question for the court to decide on referring the matter to arbitration is whether or not the dispute was arbitrable. And it was. According to the settlement agreement, there was a provision. Disputes of the amendment, easement, and of the settlement agreement would be resolved by arbitration. So that's the only thing that the court had to determine, which the court did. And the court went so far as to say that there's no allegation of fraud in reaching the settlement agreement, and so that matter was referred to arbitration. The arbitrator spent 2 days at a hearing. He took a view. He followed he analyzed his duties under the order of reference. He found violations of the settlement agreement and the amended easement. And just because the arbitrator relies upon the violation of the covenant of good faith and fair dealing doesn't show that there was evident partiality. It's a finding, it's a determination, it's a conclusion that he made. It's fundamental jurisprudence in our country that everybody is entitled to the benefits of their contract. And here, Mr. Miers got benefits in terms of parking. He got a benefit in terms of relocating the entrance and relocating the easement itself, and he got a benefit for notice. The Griffins didn't get anything. They got an easement which they can't use. They're hung up. They want to put in a septic system. They can't put in a septic system. I had to go get an order from the Superior Court to allow for the installation of the septic system, which hasn't yet been done because of the winter set upon us. But the point is that the Griffins didn't get what they expected. All they wanted, and all they still want, is access.
The arbitrator also ordered Mr. Miers to make improvements to the easement?
Well, Mr. Miers testified, it's in the arbitrator's decision, that the easement would be accessible if the Griffins wanted to regrade the entrance, if the Griffins wanted to cut the boulders in half. Regrading the easement would require a slope of fill onto the Miers' property, which he won't permit. Slicing of the boulders is, I don't know how that will be done. They're huge boulders. They are they are like a guardrail, and the arbitrator so found they are a guardrail to prevent the easement user from falling into the pond below, because it's a pretty steep drop. So he he only, and Mr. Mears suggested that the Griffins could do those things. Well, all the arbitrator said was, well, if I find that he's in violation of the covenant of good faith and fair dealing, is in violation by parking overnight, so I'm just going to have Mears do what he says the Griffins could do.
I take it there's another alternative. I presume there's some space if you wanted to move it a few feet.
Well, that's
You
an
just drive
alternative
through.
that he could have.
I just
Again,
don't know. I obviously haven't been to the property. I look at the
That's the-
pictures, but
Well,
presumably there's some other space if you move it
This
a
easement
foot here or
was-
there, left or right, you can just drive through.
This easement was used for 50, 60 years prior to this dispute arising. So there's plenty of property there, but, Mr. Mears doesn't like the burden of providing access, so he wants to restrict it as much as he can. Well, all right, that's fine, but it's still got to be accessible in the end. So wherever he wants to put the easement, that's fine. He can do what he said the Griffins could do, which is to split the rocks and regrade the easement or whatever, or he can do the easier thing, which is to put the easement back where it was over the existing gravel driveway, which was used for decades. So I suggest that there are no grounds to vacate the arbitrator's decision, and it's almost mandatory that the court confirm the arbitrator's decision unless those substantial, difficult grounds are established. And so I asked for the court to sustain the court's decision to confirm the award. I also have a motion to strike portions of the appellant's brief. I don't know how you want me to proceed with that, but it's pretty self-explanatory on the motion. The reason that I filed that motion is because a lot of those statements, unsupported as they are, go to the heart of the appellant's argument that the arbitrator exceeded his authority and showed evident partiality. And they're conclusionary in nature, and they're just not supported by the evidence. And then I also request attorney's fees, and if the court would so entertain, I'll file a motion and document the costs and the grounds for the attorney's fees. Thank you very much.
Thank you. We will take a brief recess. It's now 11:16, so we'll take a 10-minute recess. We'll be back here around 11:25.
Would all rise, please? All rise, please. This court is now in session. Please be seated.
Good morning still. So the next case we have is number 2024 P109, Craig H. Welch and another versus Commissioner of Revenue. Whenever you're ready.
Good morning. May it please the court, Michael Bowen for the appellants, Craig and Natalia Welch. In 2005, Mr. Welch, then a Massachusetts resident, co-founded a Massachusetts corporation, which was Acadiasoft. In return for forming that company, Mr. Welch received stock. Mr. Welch was an employee of the company, receiving wage income and paying Massachusetts personal income tax on that wage income. Between 2005 and 2015, the value of the Acadia business substantially increased. This growth resulted in part from the efforts of Mr. Welch.
So are you saying that because at the moment when Mr. Welch received that stock back in 2005, he hadn't done any work yet, then it can't be considered to have been effectively connected with his employment?
No, not necessarily, Justice Grant. For example, there could be a factual situation, for example, where he formed the company and he entered into an agreement with the company that this will be in return for my future services, for example. It doesn't have to be for services performed to that date. It could have been for future services, or he could have agreed, this is my comp for participating in the business of the company.
What do we do with the fact that for the first few years he was working 80-hour weeks and not getting any pay at all?
That's not unlike any other entrepreneurial endeavor. A lot of entrepreneurs run companies at a loss out of their homes, and Amazon worked that. A lot of companies work that way, where they're not making anything, with the hopes that someday they can make something. And that's exactly what happened here. Mr. Welch, for the first few years, worked out of his home along with Mr. Miers. They both worked out of their respective homes with no employees, no sales, no income, so they paid themselves no wages. They had stock, but that was stock because they formed the company. In return, they get shares back. That's how the formula of the company works. So for federal income tax purposes, well, let me go back. In 2015, Mr. Welch, then a non-resident of Massachusetts, sold that stock that he received in 2005, reported his gain as long-term capital gain for federal income tax purposes. And this is very important when we consider the department's reg. Treated the gain as long-term capital gain from his investment in the Acadiasoft stock. So the issue for the court is whether that gain is taxable to Mr. Welch as a non-resident under Chapter 62, Section 5A. Now, the Appellate Tax Board below determined that the capital gain that Mr. Welch received was compensatory in nature. Section 5A outlines when income received by non-residents is taxable in Massachusetts. That provision states that income derived from or effectively connected with a trade or business, including employment carried on by the taxpayer in Massachusetts, is subject to tax in the Commonwealth. Between 2005 and 2015, Mr. Welch was an employee of Acadiasoft and a director and officer. That was Mr. Welch's trader business. His trader business is not the same as Acadiasoft. When you own stock in a company and there's a gain associated with that stock, that's because of the company, its products, its people, its credit rating, its branding, whatever the case may be, just like when I own stock in Amazon. It's not because of the CEO, it's because of everyone who works for it that attributes to that value. Long line of cases studied in the Gaston case, which we cite in footnote 11, where the U.S. Supreme Court and also Federal District Courts of Appeal, U.S. Tax Court, note that absent an anti-abuse type of situation, the line between the company and the business of the employees are two different things, and they need to be respected. Again, absent abuse. Now, what are those abusive situations?
Can I just ask you a question?
Yeah.
It strikes me that this cannot be a terribly unusual situation.
100%.
Right, and yet, is this, and just as a side note, do we think the tax collectors are going a little bit harder at folks who are trying to move their money out since millionaire's tax was passed here? This predated this, so I'm trying to figure out where this is coming from. It just strikes me as an unusual reach by the Commonwealth for this money.
Well, Justice Brennan, you're asking a good question, and that if you want to ask a more broader question, how well the other states do it, they wouldn't be here. Other states,
right.
If you're a non-resident, it's capital gain. You're a non-resident. That income is sourced to where you reside. Yep. This is a different case. Massachusetts is going a little bit further with their statute, and as you indicated, Justice Brennan, it's not unusual. Hundreds of entrepreneurial startups happen all the time, and this situation is common. If it's that common, why isn't the commissioner put out something which would address that particular fact situation? If they want to apply their reg or the provision in that way, they should really notify taxpayers that that's what they intend to do, because they're out on a limb here with respect to their tax treatment of non-residents and capital gain.
Well, I would think the commissioner would say, well, that's, the statute made this plain, right? The legislature made this plain by adding the language, shall include gain from the sale of a business or an interest in a business, right? And that was language that was added to 5A.
Correct.
And so why wouldn't that provision cover this situation?
Excellent question. So the sentence that you're referring to, which is in 5A, just says just exactly what you said it says. It says sale of a business or an interest in a business. It doesn't talk anything more about it. It doesn't provide any sort of gloss on that. You have to go to the commissioner's regulation, which is 830 CMR 62 5A 13C8. And it states that gain from the sale of a business or an interest in a business generally does not apply to the sale of shares of stock in the CRS Corporation, to the extent that the income from such gain is characterized for federal income tax purposes as capital gain, which is exactly what happened here. Right. Mr. Welch had federal long-term capital gain. He treated it as an investment consistent with the commissioner's own regulation. Now the commissioner says, not so fast. There's more to it. That says generally. And the commissioner's regulation goes on to say, the reason there's a couple of caveats, anti-abuse being one of them. In other words, if Mr. Welch had set up Acadia Soft as a shell, that's obviously an anti-abuse situation. He's trying to avoid it. If he conspired to go across the border, potentially New Hampshire, that may be an anti-abuse type situation, but none of those allegations have been raised by the commissioner. What we have here is a situation where the commissioner is arguing, look, all it needs to be is related to his compensation. And that's the one exception in the rule, which states if the gain is connected with the taxpayer's conduct of a trade or business, including employment, as in the case where the stock is related to the taxpayer's compensation for services. So we have the general rule, which says sale of an interest is taxable in Massachusetts under Section 5A. The commissioner's reg says, no, the general rule is it's not, absent anti-abuse, or if that income is associated with compensation for services.
And that was what the tax board essentially said, is like, this was your client's life work. He threw himself into the business. He built the business. Through his sweat equity, he was compensated very little salary, at least at the start. And he was counting on making, on the business taking off, which it did, and good for him. But that means that his entire operation was sort of designed to boost the share price, and that would be his compensation for all his work in this company.
His efforts were obviously, so were Mr. Miers, so were Mr. There wasn't his company on his own. Right. Now, obviously, he made a lot of statements.
But he did a lot of the work, particularly initially.
And
right?
Bless Mr. Welch, he's a salesman, so a lot of the things he said very pride-filled. He thought this was his company, it's what he wanted to do. I'm the man. I worked all the hours. There are a lot of people working hours on this particular company, so it's right. But there's also different types of gain, right? There's compensation that he got from his services, which he was paid handsomely toward the end. It wasn't like he got paid nothing. And then he had stock that he acquired on February 11th, 2005, which he held, right? Now, when I say I'm expecting a payout, that could be investment income, right? That could be capital gain associated with the fact that...
Does it matter that he didn't pay anything for the stock in 2005?
It doesn't make any difference from the point of taxability for the commissioner here at all. I'll let Ms. Opposing counsel speak to that, but it doesn't matter at all. He formed the company basically on, with no money and just with an idea of what he was going to do. And he and Mr. Miers founded it in 2005 with the goal of growing the business and eventually exiting out. Because as Mr. Welch has testified in his deposition, he's an entrepreneur. He wanted to get it to a certain point and get out. which is, again, Mr. Justice Brennan's point, pretty common amongst entrepreneurs. They don't want to end up running a business. They're usually serial entrepreneurs who want to continue to just go on to the next business and let a VC or other institutional investors come in and just take it and run with it. I'll cash out and I'll go on to the next one. In this case, the compensation that Mr. Welch received was the W-2 income, which he paid Massachusetts personal income tax on. What we're talking about is the capital gain on his stock that he didn't get for compensation, and that he eventually sold when he became a non-resident in 2015. It's that gain that the commissioner is seeking to tax under Section 5A.
What if he'd sold the stock when he was still a resident of Massachusetts?
Would have been taxable in Massachusetts. It's the fact that he became a non-resident that the Commonwealth loses jurisdiction to tax that income. Again, in every other state.
Except under 5A.
In every other state, except the Commonwealth under Section 5A and their interpretation of it. And the court, I don't know how many tax cases you do, having watched the earlier arguments, probably not that many. But in the tax world, as I mentioned, there might be in other areas of law, tax laws, to the extent that there's any ambiguity, are construed strictly in favor of the taxpayer. And what we have here we're arguing about the ambiguity in the tax law. What does it mean for it to be attributed to, connected with, resulting from the individual's trade or business in Massachusetts? The way we view it, our interpretation obviously, is it needs to be compensatory. It needs to be for performance of services that you got that particular income. And there was no agreement from 2005 to 2015 where Mr. Welch agreed that any of that capital gain that he was going to have a big payout from was going to be as a result for compensation for services performed in 2005.
What about the 2009 agreement as part of that refinancing that named him a key holder, and it tied his remaining with the company to his right to sell the stock at a favorable
Our first
amount?
question-
Why doesn't that show that they're related?
As you might guess, Justice Grant, our first argument is you're looking at the wrong time. You look at when he received the stock. Why did he receive that stock in 2005? Was it for compensation? It clearly was not. He received the stock because he formed the company. That's our first argument. But to more directly at your point, so the VC or the institutional investors came in and said, look, we're going to put money in, but in order for us to put money in, you need to stay. To Justice Brennan's point again, that's common. Anytime institutional investors come in and they're investing in the company, they want to make sure the key employees stay. And that was only an 18-month window, right? And what the commissioners here is saying, because of the 18-month window, 100% of the gain is taxable in Massachusetts, even though the hold period was only 18 months of the 10 years that Mr. Welch held the stock. So that's a difficulty in the commissioner's position, arguing that that hold provision somehow means that 100% of the gain is taxable in Massachusetts.
I think you hit it when you said we don't do a lot of these. So let me ask you a broader question. Does this case, is it consequential more broadly, or is it really, you think, limited to the facts and the results of this particular case?
It's incredibly more broad, and there's two different pockets where it could become a problem.
Right. That was my sense, but I don't know enough to know if I'm right.
Because it's not just a non-resident situation. You could have a non-resident, for example, the department's example in its regulation has an example of an investor. The investor is a non-resident. He works for a Massachusetts he or she works for a Massachusetts corporation. He's an employee or she's an employee of the corporation. He acquires stock for purposes of investment not related to his compensation.
But he purchases it.
Purchases it. That example, we believe, is strictly on point to Mr. Welch. He was a non-resident. Now, he acquired the stock. He didn't purchase the stock from when he formed the company. He was an employee of the company. What's the difference? The example assumes away the legal aspect of the determination by saying he acquired it for investment. But the way we look at the example is that that example doesn't distinguish between the level of involvement of the employee. It doesn't say this was a receptionist or this was a senior vice president. It just says it was an employee. It doesn't talk about how much involvement that individual had at the company. None of that matters to the example, but that's exactly why we're here. And if the commissioner wants to make that point, it needs to provide an example or make it clear in the law that these particular situations, but to your point one more time, I think it will chill entrepreneurial investment in the state at the end of the day. If I'm a non-resident and I want to invest in the workforce that they have in the Commonwealth, especially in the Boston area, to be able to do my work for me in tech or whatever else is going to, I'll think twice about it. Because if I form a company and take out stock and later on I cash out, I'm going to be paying Massachusetts personal income tax, even though maybe I never even set a foot in the state. So, go ahead. I'm sorry.
So the decisions of the board as to our findings of fact are final, right? And I guess the question is this issue about the board determining that this money was compensatory, is that a finding of fact that we are kind of bound by?
That's not a finding of fact, that's a conclusion of law.
Conclusion of law, okay. And is it supported by underlying findings of fact, or do you think it's entirely, the extent to which this is compensatory, that's entirely a question of law that we should review de novo in your view?
If you read the ATB decision, the Appellate Tax Board decision, I believe, I'm not speaking for the commissioner, he's basing it off of the 15 pages in the middle where he talks about Mr. Welch's involvement in the business and how much participation he had. The argument that I've given you today is that none of that matters. At the end of the day, what matters is, in 2005, did he receive that stock as compensation or not? Or did he agree at a later date that somehow that was going to be his comp for running the company? And that is really what matters under the Commissioner's regulation and under Section 5A.
Thank you.
Thank you. Thank you.
Good morning, Céline de la Foscade-Condon for the Massachusetts Department of Revenue. May it please the court. Under the appellant's argument, the capital gain from the sale of a C or an S corp stock would never be taxable to a non-resident. But that's not what the statute says, and that's not what the regulation says. With the amendment to the 5A statute in 2003, the definition of Massachusetts source income was expanded. That definition specifically mentioned that mass source income can include the gain from the sale of a business. And the regulation, which was adopted in 2006 and amended in 2008, echoes the statute. The regulation also refers to mass source income, including the gain from the sale of a business.
May I ask you a question? Do you agree with the proposition that really what is at the crux of this case is whether the 2005 stock was received as compensation for his involvement in/running the company?
That's what the board found. The board found that the income at issue was in compensatory nature, but even if it's not compensation, it would still be taxable because it is related to a trade of business conducted in Massachusetts.
Do you agree that the question of whether it's compensatory is a conclusion of law as opposed to a question of fact?
No, I do not agree with that. I do think that the findings that it was compensatory in nature is a finding of facts, which makes the decision final, because the findings are supported here with substantial evidence. One, the taxpayer found that it was compensation, right? He wanted a payout. He was looking for a payout for all the hard work that he put in the company, all the long hours. Two, he was not paid much at the beginning when he started the business. And even at the end, he was paid $200,000, which is...
But you don't disagree with the proposition that that is not unusual for an entrepreneur, that when you start a startup, first few years you can pretty well expect you're not going to be pocketing a lot of money in terms of income if you're a principal.
I agree with that.
Okay.
That's very common. But also the documents and Justice Grant, the document that you mentioned, the right of first refusal, really tie the stocks with his compensation, right? If he was resigning from the business, he would have to sell the stocks for a penny per share, which at the time with the number of shares that he had would come up to $1,000. So really, the stocks and the employment are tied by documentary evidence.
Can you just in general, how do we assess the amount that some employee is paid in salary as illuminating this issue about whether the stock is compensation or not? So if the employee had been paid, $300,000 from year one and we went up gradually, that would kind of weaken the board's conclusion as to whether this was compensatory, because it would be something else, right? I'm just trying to understand like, the logic here of sort of how we assess that the initial years he was paid only $7,000 or less than that.
You can have different type of compensation, and it's not because you're receiving wages that something else is not compensation. I mean, I see as a public employee, you have like wages and you have deferred compensation and you have your pension income. Those are different type of compensation, yet they are both related to my employment or to the trade of business that I'm conducted in Massachusetts, and that's why it is taxable. To the point of my brother actually talking about all the activities that Mr. Welch conducted in the business and that the board went very much in detail, I think that is very critical. I mean, that's the difference between Dupuy and Gaston case and this case, right? In Dupuy and Gaston, where you had taxpayers who were involved in the Celtics, but just sitting on the board of directors and not involved in the day-to-day operations. And in those two cases, the SJC and actually the board in Gaston went into very much details as to the operations those two taxpayers were not involved in. They were not involved in negotiating contract for the players or getting leases. And on that basis, the board and the SJC found that he was not taxable because he was not related to a trade of business the taxpayers conducted in Massachusetts. Here we have, I'm sorry.
Well, is it an issue of control? Is it passive versus active? Is that an issue of like the extent to which he's controlling the business, or is it an extent to which he's involved in furthering the activities of the business?
Right, so really looking at the Gaston and the Dupuy case and the Welch case and other cases related to this issue, it's really the amount of involvement in the day-to-day operation of the business. And actually, when you look at the definition of what is trade of business in the regulation, is for the taxpayer to be systematically and regularly involved in the operation of the business to make it a trade of business. So here, that's really what we have, right? Mr. Welch was involved in every single aspect of the business, not only founding the company and creating the product, but he was involved in personnel matter, in financing matter. And for that reason, it is taxable by Massachusetts.
So again, that's, I guess, where I'm missing a piece of it, because I understand that, and I presume that his compensation then was commensurate with whatever his involvement may have been. So presumably, he made more than an administrative assistant or a custodian who works in, if he had, I don't even know if he had physical brick and mortar buildings, but, right? So that's the compensation. That's what he's taking out of it. Why is it that when he and his partner get together and say, let's start up a company, 50-50, we each take 750 shares of stock, and we're just, I mean, they're essentially just creating the stock out of thin air, I mean, in essence, right? How is that compensation? I just don't, for what he's putting into the company at that point, for his day-to-day operations?
Well, because, as I said, first of all, that's the way that he sees it, right? That was the payout that he was looking for. That was all the hard work, because he worked a lot. I mean, 80 hours a week, he worked during the weekend.
But he got them in 2005, that's what I'm saying. When he got
Right.
when they created the shares in 2005, is it your position that it was compensatory at that time?
It was compensatory the entire time, from the time that he got the stocks, because he got the stocks with the expectation of the payout, right? I mean, he worked really hard to make the shares valuable and to get that money at some point. But again, even if it's not considered compensation,
Okay.
it would still be taxable because it is related to a trade of business conducted in Massachusetts, and that's what the statute and that's what the regulation requires.
So that language that was added to 5A in 2003, whether or not the non-resident is actively engaged in a trade or business or employment in Massachusetts in the year in which the income is received. As I understand it, we don't have any published cases yet really construing that language other than the footnote in VAS Holdings.
Yeah, so this change in the statute came from the Oliver case. There was a series of cases prior to 2003 where the taxpayer received income, and the Oliver case, for instance, was pension income. So that was really related to his trade to his employment. But he had moved to, I believe, Florida at the time. And prior to 2003, the court read the statute as requiring the taxpayer to be in Massachusetts the year of receipt of the income for it to be taxable. So here, I mean, if it's determined to be mass source income, it doesn't matter that the taxpayer be in Massachusetts the year of receipt.
Can I ask you this? So, for example, and you can tell me if I'm way off base on this, but State Street Bank, that's a Massachusetts corporation, pretty sure? Assume it is for the moment.
Yes.
And someone works there but lives in New Hampshire.
Yes.
And they just decide on their own to buy some stock, okay? And then they're working for the bank in whatever capacity, in an integral capacity. And this, again, it's not something the bank gave them. They just decided on their own, I'm going to invest because I think it's a pretty good company. And then they cash out that stock. You're saying that that is taxable as a capital gain in Massachusetts for a New Hampshire resident?
No, so
Doesn't make sense to me.
Because here that would fall within the example of the regulation when you have the employee of National C Corporation who is a non-resident but an employee of the corporation and buy stocks as passive investment and then cash out the stocks, and it's not taxable. Because
So then the critical question really is, what was it in 2005? What was this? Right?
Because here again, I mean, not only the board found it was compensatory in nature, in the sense of like he got the stocks because he founded this company in the hope of making money. And that's exactly what happened. And he made that money by creating that business in Massachusetts. But also, I mean, because here it is effectively connected with a trade of business he conducted in Massachusetts, that makes it taxable.
What do you say to opposing counsel's argument that it's not his trade or business, it's Acadiasoft's?
Right. So, I mean, you always have this issue of like the separation between the corporation and the business of, the two, of course, are related, but like really the business of the corporation really refers to the overall operations and the activities of the company as a legal entity. While the business of the officers and directors, and who we're talking about here, really refers specifically to the management and the decision-making responsibilities of the individuals, really, that are appointed to lead the company, and generally with the directors overseeing like high-level decision, while the officers are really handling the day-to-day operations. So the two are linked, but the two are separate. And here we've never imputed the activities of Acadiasoft to the taxpayer. We're only looking at the taxpayer. We're only looking at Mr. Welch and the activities that Mr. Welch conducted in Massachusetts. And that is a reason why it is taxable, not because Acadiasoft was operating 100% in Massachusetts. The commissioner never asserted a position.
We were talking a little while ago about this language added in 2003, and the fact that there were all of these cases, the Celtics cases and Oliver 10 or 20 years ago, about whether or not the person was a resident. And now with this new language, with this whether or not they were a resident at the time of the, I don't have it in front of me right now. Are there other cases pending or percolating through the system, either at the ATB or in other cases where this language is going to be construed?
Because they receive the income later on, or whether it's mass source income, yes, we do have cases within the Department of Revenue where this issue of mass source income is percolating. And some are pending at the ATB right now, yes.
But other than that footnote in VAS Holdings and the way that I think it was Dupuy sort of said, we're not going to apply the new language. There's no published case out there that construes that language.
Well, the only decision that was, you have a MACT case, but it's a 128 decision that was decided in 2011. So while it's not a binding precedent, it still has precedential value. The MACT case is great in the sense that it was regarding the years 2002 through 2005. So it's pre-amendment and post-amendment. And in that case, it was. I mean, this court.
It was
actually,
McTagg I was thinking of, not
right.
Dupuy. Yeah.
And this actually in McTagg, this court, affirms the board's decision that the income at issue, which was the interest income on the note was taxable because it was related to the trade of business that the taxpayer was conducting in Massachusetts for the years after the amendment to 2003.
Is it, so again, you may or may not know this, but is it a function of taxes being collected in these situations differently now and over the past several years? It does seem unusual. There's almost a 20-year gap.
No, I mean, this case, I mean, most of those cases come generally as domicile cases as to whether or not, so the taxpayer claimed to have changed his domicile, and it's looked at it from a domicile perspective. Here, we abandoned the domicile issue because the taxpayer had sold his Massachusetts property and therefore cannot be found to be a resident of Massachusetts. But we looked at it then later on as mass source income. So even if the domicile issue is not an issue anymore, there is still an issue of mass source income. But most of those cases come as domicile issues. So just to finalize the argument here, really the difference between Mr. Welch and the angel investors, for instance, that got the same type of stocks is crucial because, like, the angel investors got the stock as a pure passive investment, right? They were never involved in the day-to-day operation of the business. But Mr. Welch was completely the opposite. He was involved in every single aspect of the business. And for that reason, because he was involved in every single aspect of the business, and because the capital gain was related to the trade of business that he conducted in Massachusetts, it is taxable in Massachusetts, and we would therefore request that you affirm the decision of the board. Thank you.
Thank you very much. So we have our fifth case, which is 2024 P421, and it is Stephen B. Korn, MD, versus Brigham and Women's Hospital and others. Good afternoon.
Good afternoon. May it please the court, Dana Kerhan for Stephen Korn. We challenge the entry of summary judgment on claims of disability discrimination and related counts. I want to start out by arguing that a reasonable fact finder could determine that Dr. Korn was an employee. And at a minimum, there was a dispute of material fact as to whether he was an employee in 2016 at the time of his discharge. When he was initially hired, there were two components of his employment. There was the clinical and there was the non-clinical. And when he went on disability, the clinical portion of his employment was replaced by disability insurance. The non-clinical portions, as to which he wasn't separately compensated, those continued.
But you're not disputing that he was not being compensated monetarily in any way by either of the defendants or any?
Well, I actually am. His health insurance and his retirement contributions were made during the time he was on disability.
That's true. If I retire, when I retire, who knows when they'll be from this job, though, I'll get insurance benefits, right? But can't say I'm still working as a judge.
You'll get insurance benefits. You wouldn't necessarily get contributions to your retirement.
Well, that's because I'm collecting it.
Well, how did that work? How did he get contributions for his retirement? Tell me what contributions were made after 2011.
I'm not sure the form they take. It may have been the form of a 401k. I think that this fact is undisputed.
Is the Brigham the employer? Is that fair? Or was the employer making contributions?
The employer was making contributions to his retirement.
Matching contributions, or?
I don't believe they were matching contributions. I think they were just making contributions. And
it was 401k?
To some type of retirement account, and I don't know the form, but this was not a disputed fact.
What work was he doing after 2011?
He was doing some research. He was doing some supervision. He was teaching in Harvard Medical School.
He was teaching, affirmatively teaching? He had the affiliation. Was he actually instructing people?
He was required to do 50 hours of work that could take any form. It could be teaching, it could be supervising it could be supervising medical students, things like that.
What's the record here? What's the record here? What was, I just don't recall. What was he actually doing based on the record in this case?
I'm not sure the precise nature of what he was doing, but he was, I will say that he was satisfying the requirements of his teaching appointment.
How?
I'm not sure, and it may have
Okay.
varied from year to year, but nobody said that he didn't. Let me put it that way.
Right.
So
I mean,
he
there's a
was,
lot of Harvard-affiliated professionals who may not live up to their, commitments under that affiliation, right? I mean, that's the fact that that affiliation was supposed to be doing 50 hours of teaching doesn't necessarily mean that he was,
well,
does it?
there's no allegation anywhere that he wasn't.
Okay.
And I think if he wasn't, that fact would have come out somewhere in the record.
What is the evidence about him being a PI on a grant? Is that in the record? I saw some reference to that, being a preliminary or a primary investigator.
Right. He was director of clinical innovation. There was a grant funded in his name. He had access to it. I think it may have been $25,000, but he had access to it, and he. I mean, let me put it this way. I think there's no allegation that he did not fulfill his non-clinical duties. The only question is, does the fact that he was no longer doing his clinical duties, does that make him not an employee? And he was receiving compensation from his disability insurance that effectively replaced his base salary. And that was paid for by the employer.
What's your definition of an employee for purposes of 151B?
Well, somebody who performs work or tasks for the employer. And it is.
I mean, you're saying, well, there's no allegation that he wasn't doing his non-clinical work, but is there any evidence that he was doing any affirmative evidence that he was acting as an employee during this period?
Well, I mean, he wasn't doing his clinical work during this time because he was actually ready to come back and do it. And around 2011, there was some discussion. There was a letter from Dr. Vacanti where he said, I'm pleased that you're coming back and you're going to do your clinical work, and we'll do our best to accommodate you. And then that changed.
But it can't be someone who performs a task, right? Because that would include volunteers, for example, who are not employees.
Well, somebody who starts out as a volunteer, I don't think is an employee, and there's case law on that. So
what about someone who starts out as an employee under the more literal, I suppose, or generic definition, then becomes a volunteer?
That has not been decided. Okay. I found no case law addressing that issue. And, again, where he was receiving some compensation in the form of retirement compensation, contributions, and he was receiving employer-provided disability insurance, and he was receiving his health insurance. I mean, there was at least some compensation there.
Before we get too far down on the clock here, can you take a few and discuss the timeliness issue?
Yeah, I mean,
Seems to be a tough hurdle here that he didn't know.
Here's the problem. He didn't find out until the discovery phase. I mean, the reason he went on disability, and he was told to go on disability in 2011, is that he could not meet the clinical requirement that he appear solo at least 5 times a year in the operating room.
You're saying he did not know that the defendants would not reasonably accommodate him until he got discovery?
Until later on. When he got discovery, he found out that half of the clinicians were not meeting that requirement, and that it was not actually a requirement.
Right, but that's a different issue as to whether they would actually accommodate him on his request for the no solo in the OR.
Well, I think the problem I have is that if there's no solo in the OR, but that's not actually a requirement, then I think there's an ongoing violation while they conceal that from him. And I know the courts in Massachusetts don't like ongoing violations, but I think until he found out that that this was not an actual requirement, and that to the extent that it may have...
He knew enough to file a lawsuit before he got his discovery, though, right? It seems like a sort of a circular argument to me.
Well, I mean...
And how did he know enough to file a lawsuit if he didn't know?
I think he thought that this is a requirement that could have been accommodated. And,
right.
But, you know, it turns out it wasn't a requirement, and it turns out it wasn't being enforced against other people. So, again, there was at least one physician who wasn't required to go into the OR 5 times a year. And there were others, there were half of the department wasn't meeting that requirement. So, you know, I think that that establishes, because they didn't...
You're saying he did not know or should not have known that he was harmed by his employer's conduct until he received discovery after he filed a lawsuit claiming that he was harmed by the conduct?
He didn't know the extent of the harm and the...
I'm not talking extent. The question is whether the statute, because I understand the statute, it begins to run when he knows or should have known that he was harmed by his employer's conduct, right?
Well, okay, so he knew that he wasn't being accommodated, but he didn't know that the specific requirements that were not being accommodated didn't actually exist, and that he didn't actually, and that, you know, they weren't being, if they did exist, they weren't being enforced. And that's really the problem. I think that he didn't discover that until after he filed his suit.
The judge cites the Wheatley case that says the discrimination cause of action arose when the plaintiff received notice of the adverse action, not when he learned of the improper motive underlying it. Doesn't that sort of cut against your position here? I mean, he certainly knew about the adverse action when he was denied in 2011, right? And it's the fact that he found like this evidence that supports his case much later.
Well, I mean, I think... I don't think that analysis is correct. I mean, again, Dr. Korn knew that he wasn't being accommodated as early as 2011. But he also didn't know the requirements because they falsely told him that you have to be in the OR 5 times a year solo.
That applied to some people, right? It was just the pediatric, or the... it's not pediatric. The
Children's Hospital.
Pediatric anesthesiologist, right?
I think that it did not apply to his department.
Right.
And it is something that was not told to him. He was actually told something completely different. So,
Speaking of things he didn't know, could you talk to us a little bit about the betting pool and whether or not you're asking us to expand College Town?
well, I mean, he knew certain things. He knew that people were making disparaging remarks. I think, again, he didn't know the extent to which things were happening. He didn't know that there was a betting pool until, I think, 2022 maybe. And, you know, that's something that there's, I guess, how much of a hostile work environment is there if you don't know about it, but it was a lot of it was just behind his back. And so, again, he knew some of it. He knew people were complaining that he was lazy and that he, you know, didn't want to work, but he didn't know that there was a betting pool, which is particularly offensive, I think.
But if these are the coworkers that are having to pick up the slack for him, does that fit within College Town?
You know, I think if you are complaining that I have to pick up the slack and I have to do extra work for him, that may be legitimate. But I think if you're doing a betting pool as to when he's going to have his next episode, and I think that sort of goes beyond College Town. I don't know if, the problem is that there's not a lot of law directly on point in this, and, you know, that is a little bit of a problem. And, you know, there is some concealment here, and again, when you're looking at his employment, all of these non-clinical things were clearly a part of his employee when he was collecting a salary. He was paid a base salary, but he was expected to do all of these things on a volunteer basis. Now, he didn't start out as a volunteer. I think if I go and I volunteer for Habitat for Humanity because I think Jimmy Carter is wonderful, then yeah, I'm a volunteer and I'm not an employee. There's no case law in Massachusetts that says what happens when you start out as an employee and work there for, I think he worked there from 91 to 2011 or 2016, depending on what this court decides. He continued with his non-clinical. He was compensated at least in some manner, and I think a reasonable fact finder could find that he's an employee.
So your argument would be, well, the Brigham formally made him an employee at some point, so it had an obligation to formally terminate that relationship, would not just sort of glide through and say, well, we'll let you keep your titles and your office and keep it kind of vague.
I think so. And, you know, he had access to HIPAA files and things like that, and a key card and an email account, all that other stuff.
Before you run out of time, so let's just assume he was an employee in 2016. What is your response to the judge's ruling in the alternative that even if Dr. Korn was an employee, he didn't establish that he was a qualified handicapped person as of 2016 because he didn't request an accommodation or seek to return to work? He was just complaining about his honorific and academic titles being removed.
Well, I mean, he wanted to return to work in 2011. Now,
yeah, but 2016.
Right, 2016. Obviously, he knew that he couldn't meet the non-existent requirement that he appear 5 times a year solo in the OR. So I think that is really a consequence of the defendant's own conduct.
But if the claim is, if there wasn't a claim beforehand, and we're just looking at what happened in 2016, didn't he have some obligation to sort of say, request an accommodation at that period, even if he thought he wouldn't get it, just sort of to make to satisfy the elements of a claim?
Well, I mean, I think he was misled, and you know, he did make the accommodation, the request for an accommodation in 2011, and he was told, go on disability. So I don't think it's his fault. Okay. I think a reasonable fact finder could find that he was an employee.
Yep.
Thank you.
Thank you.
Good afternoon. May it please the court. My name is Toby Bright on behalf of the Appellees, Dr. Rathmel, Brigham and Women's Hospital, and Partners Healthcare. The appeal comes before the court following the allowance of a motion for summary judgment at the trial court. It appears that you're familiar with the facts, so in very brief summary, adopting the facts found by the trial court and in the light most favorable to the appellant was first hired as an attending anesthesiologist in 1991. In 2006, he first requested an accommodation for a disability related to a gastrointestinal disease that was denied. In 2011, he was granted the accommodation that he had requested, which was the exemption from working alone in the OR, and notably from 2006 to 2011, the requirement to work 5 times alone in the OR was not enforced. He only worked a total, and this is in the court's finding, of 7 times in those 5 years. So it, certainly on notice that the requirement wasn't going to be enforced as to him. In 2011, he decided that he could no longer, even with the accommodation, work in the OR.
Do you agree that, just let's jump to it. Do you agree that after he became, and I forget what, honorary employee, that there were ongoing contributions to his retirement account or to a 401k?
Sorry, so as part of the disability policy, he received disability payments from the disability insurer, and the department continued to contribute to his 401k and pay his health insurance. And that continues to this day. It actually continues to the day of his retirement, or he reaches retirement age, which will be sometimes this year. I can't remember his birthday. But those contributions continued completely irrespective of his association. So if he had, in 2011, moved to Florida and never set foot in the Brigham again, he would continue to receive exactly that. And I guess anticipating this line of questioning, that is the fact that that some benefits were paid on his behalf continued. That isn't remuneration in exchange for employment. Under the basic plain meaning of the word employment, under Black's Law Dictionary, it's contract for hire. And under
What's your definition of an employee?
That would be compensation in exchange for work. As the Lowry Appeals Court in the appellate decision state, the primary feature of employment is the quid pro quo of work in exchange for payment. He certainly never received any payment in exchange for work, and we dispute, and the record is extremely thin, that he was actually doing any work.
What happened to him? What did he turn into in 2011?
Well, he received the honorific title of honorary staff member.
But what was he? He wasn't a volunteer. He wasn't an independent contractor. What was he?
Well, he was a former employee maintaining an honorary title. The closest analogous situation would be that of an emeritus professor or a volunteer, frankly, because the few activities that he did do were done strictly at his own discretion and at his own leisure. He wasn't required to do anything.
As an employer, like gets back to my question that I posed to your brother, an employer formally made Dr. Korn an employee. Doesn't the employer have some obligation to sort of terminate that relationship formally? Because it seems like they took the path of least resistance here by, well, we don't want to deal with this. We'll let him stay in his office, give him some honorifics, and let him keep going. But they didn't actually sort of say, you're no longer an employee. Isn't there some obligation to sort of formally end the employee-employer relationship in order to cut off liability?
So I'd say two things. One is that there's no legal requirement to file any type of specific pleading or document to say you are heretofore no longer an employee. But I also say that the record is just quiet on this because I'd suggest the material facts aren't whether or not he received a notice. He certainly knew he was on disability. He certainly knew that he was made an honorary staff member. He cited that to Dr. Rathmel, it's in the record, when Dr. Rathmel became the chair of the department, said, Dr. Vacanti made me an honorary staff member, and these are my, and he actually quotes to him the bylaws defining what an honorary staff member is. And so there certainly can be no argument, certainly not based on the record, that he was unaware of this change in his employment. He knew he was receiving disability. He knew that he was an honorary staff member. He knew that he no longer had clinical privileges.
Would someone in the outside world have known that he was an employee?
That's a fair question if we're talking about issues of agency.
Well, yeah, certainly. What if he had committed a tort? Would the Brigham have been on notice? Would it have been on the hook for liability for his tortuous conduct? I mean,
sure. Under a theory of apparent agency, it would certainly be a question of fact, whether or not he appeared to the outside world. But apparent agency is applicable to third parties. Apparent agency doesn't create an employment relationship between the agent and the servant, the apparent agent and the servant. That's strictly an analysis to the third party who's been harmed by what appears to be an agent. So again, under 151B, it doesn't redefine employment as one of appearance.
What if, let me ask this, what if he had a miraculous recovery while he's on his honorary staff member status? Could he then say, hey, give me some surgeries, I'm ready to go?
He would absolutely be considered for a potential.
Or would he have to be rehired?
He would need to go through the rehiring process as anybody else would.
Is that in the record anywhere, or are we just supposed to?
Yeah. Well, so that would be a hypothetical. He never did request to come back.
That's fair.
And it was
just in terms of whether he's an employee or not, because if he were just a person on the street with working as a volunteer in there who had a digestive issue, and then he said, no, I really can't go in the operating room by myself. And then 6 months later, he said, oh, wow, I get this great medication, now I'm good. I can go in there, right? He's still a volunteer.
Certainly. Well, he wasn't on the payroll, so they would have to find payment for him. He wasn't clinically privileged to do any operations, so he'd have to be re-credentialed to obtain privileging. So he'd have to essentially restart the process.
All right.
And whether or not his his years of prior service would be credited. That's
So in terms of whether he's an employee, your position, I think it makes sense. He couldn't have just stepped next door and signed up for a surgery.
Absolutely, and there's nothing in the record that suggests otherwise.
Is it a factual issue for a jury?
Whether or not he could be rehired?
Whether or not he was an employee? I mean, you don't seem to have any kind of clear case law that says in this kind of unique situation,
Well,
you're no longer employee if you kind of go on disability, but you have your honorary, Harvard affiliation, and you keep going and you keep your office, right? It seems like there may be enough here for this to be a factual issue that might have to go to a jury.
I think the only material facts is the question of employment, whether or not he was working and receiving compensation in exchange for work.
And where do you get that test? Where does that test come from?
That test comes from the Lowry v. Clem Appeals Court language, as well as Black's Law Dictionary, both employment and contract for hire cited in here. And Lowry v. Clem is very clear that uncompensated individuals are not employed. And both the SJC and the Appeals Court speak to the public policy reasons behind employment statutes, which is that for individuals relying on employment, the negative aspects of discrimination are in play. If someone's not relying on their affiliation to survive, the discrimination question is different. And Lowry v. Clem and the SJC, they speak to that. And I'd also note that Judge Gordon cites the Zelnick and Peterson cases, which are cases from other jurisdictions involving professors emeritus. And both those cases, one from Ohio, one from the Second Circuit, found that these emeritus affiliations are not employment. I've spoken now, I think, adequately with regard to our position on whether or not he's employment, but then the second question, second primary question in my view is whether or not the loss of the honorary affiliation while in disability would be a continuing violation for allegedly discriminating acts occurring prior to going on disability, and I'd submit that the answer to that is not. With regard to the continuing violation, whether you view this as a failure to accommodate or as a hostile work environment, trial court found that he had clear and unambiguous notice in 2011 of his claims. I would submit that there is no ambiguity on the failure to accommodate. Ocean Spray speaks quite on point that failures to accommodate are discrete acts not subject to continuing violation. So there's no dispute that he knows that, or at least that for purposes of this argument, assumed that he was not accommodated in 2011 for his request to not work solo in the R. He knows that was, or for purposes of the argument, that was denied. So he was on notice. The 300-day statute of limitation began to run at that point. With regard to the hostile work environment, it has been the plaintiff's contention from the complaints on page 19 of the record appendix. Page 19, actually paragraph 19 of the record appendix. It is his contention that the defendant's failure to accommodate him in 2006 to 2011 is what caused him to lose his ability to work clinically at all and required him to go on total disability, at which time he attested to the inability to do that. And as the trial court found, it's clear and unambiguous at that time that the change in circumstances would trigger a reasonable person believing themselves to be unable to perform these duties because of the alleged discrimination would be on notice of the charge. And this is a holding in Cudger. Continuing violation doctrine doesn't serve to extend the statute of limitations indefinitely. It goes to when a reasonable person will understand that they have a claim. And the trial court, as I said, wrote a very thoughtful and thorough decision on this issue. Related to that, the trial court found that the loss of the honorary affiliation did not anchor, meaning the decision of the new chair 5 years later, who had nothing to do with anything between 2006 to 2011, was a completely independent act, not related to any decision relating his clinical work in the OR from 2006 to 2011. So even if you were to find employment in 2016, the loss of his honorary affiliation is unrelated to what happened between 2006 and 2011. The final aspect of the appeal relates to certain common law tort claims. They were not thoroughly briefed at the trial court and not thoroughly briefed now. I would submit that the record is absent of facts that would support a genuine dispute of fact on any of the quantum merit, the misrepresentation, or the tortious interference claims. And so we'd ask that you affirm the judgment of the trial court. Thank you.
Thank you. And our last case for the day is number 2023 P1399, Essex Northshore Agricultural and Technical School District versus Commonwealth Employment Relations Board and another. And I understand that the appellees will be splitting their time, 7.5 minutes each for SERB and the union. So when you're ready, thank you.
Thank you. Good afternoon, Your Honors. May it please the Court. My name is Brett Zabag on behalf of the Essex, the appellant Essex North Shore Agricultural and Technical School District. For the purposes of the argument, I'll refer to the appellant as the district. It is kind of a mouthful. Your Honors, the district is asking that you set aside the board's decision that the district violated Chapter 150E by unilaterally changing employee work hours during the summer of 2020. The parties have a collective bargaining agreement or a labor contract that authorizes the district to take the actions that it took by closing the school on Fridays. The parties bargained to get the language in the contract, so there's no requirement that the district bargain further over that. As you know, as an apparent from the parties' briefs, this occurred in the summer of 2020. The school was closed per order of Governor Baker due to the state of emergency in March of 2020. All of the employees were home receiving their full pay. When they transitioned back into work, the district explored measures to save costs given the uncertain financial situation attendant to the
Can I ask you this?
Yes,
you're referring to the bargain for language of the contract. That's the Article 5 language?
Yes, Your Honor.
Okay. And so their position is, okay, you can flip our shifts around. You can say, oh, you know, let's, instead of working the same amount of hours Monday through Friday, do it Monday to Thursday. But when you change the number of hours, and maybe they'll correct me, so I'm sure if I'm wrong, but if you change the number of hours and then say, and by the way, you got to take vacation time or personal time or just going unpaid, that's different in substance than what we bargained for.
I understand. I do believe it does encompass schedules, Your Honor. If you were to say, you know, an employee's schedule is, say, you work Monday through Friday, 7 a.m. to 3:30. By changing an employee's work schedule, you could say, okay, well, now you work Monday through Thursday.
Are the hourly employees, does it make a difference if they're salaried or hourly? Because if it's salaried employees, I'm sure they'll say, hey, great, I'll work Monday through Thursday.
Right.
Sounds good.
Some are hourly, some are salaried, Your Honor. There are, in the bargaining unit, there are some 10-month employees, which are school year employees. Some are 12-month employees. And I do believe that the contract is clear that it gives the district the authority to do that. And even
They say that you're basically taking me as a full-timer and now making me a part-timer.
Well, even if you were to look at the other part of Article 5, which again, you know, this would be ordinarily a mandatory subject of bargaining, hours of work, employee schedules, had it not been bargained for in the contract, Your Honor. So if you were to look at the second part of Article 5, where it gives the district the authority to modify employees' work years to best meet the needs of the district based on reasonable notice, you know, that if you were to shorten or lengthen an employee's work year, that necessarily includes, in this example, if you were to shorten it, that would include a reduction of the months, weeks, days, and hours that an employee would work. And so
They said, oh, by the way, you know what, I think we need a cleaner building, so all of the custodial staff, you're going to be coming in 6 days a week. In fact, let's make it 7. So now you're working 7 days a week. That's just a change in the schedule, right?
it's a change in the schedule, it could be a change in the
Do
work
that
year.
without some more bargaining?
If
They're
it's in the
adding a couple
contract.
days onto it and paying us, basically, even if it's an hourly employee, but you're now requiring people to come in every Saturday and Sunday.
If that's what it says in the contract.
Under Article 5, that's what I'm saying.
Yes, Your Honor, that's the district's position.
Okay?
So you rely on the language in Article 5 about different work years, and you're saying, well, that's sufficient to allow imposition of a furlough?
Yes, Your Honor. If you were to shorten an employee's work year, say, from 185 days to 175 days, that's 10 less days that the employee works and not being paid for those days.
Right, that if you shorten, but you're saying, well, that means that's the equivalent of imposing a furlough, right? But that's different from imposing a furlough, right? It's one thing to sort of shorten the overall work year by 10 days. It's quite a different thing to sort of say, okay, during the summer now we're going to cut a day out of your schedule and you can use vacation leave to make that up if you want, right? It just seems a fundamentally different thing. Obviously you've got some bargain for, you got some authority in Article 5, but it seems different from what Essex Tech actually did this summer. And I guess that's the problem, sort of like it's like you're proceeding by analogy to the authority that you bargained for, but you did something different.
I mean, did we technically shorten their work years?
Yeah. No, you didn't, right? Yeah. So you
But
did something different. You said, "Wow, it's like if we shortened the work year, right? But we did it differently, right? But it's different." And I guess how much reasoning by analogy are you allowed to do when you acknowledge that the fundamental underlying matter of work hours, wages, and vacation leave are subject to bargaining?
Well, Your Honor, I believe the standard that's the waiver for contract argument. It's either by expressly or necessary implication. So the language of Article 5, by necessary implication, if you're altering an employee's work year by shortening it, you're reducing their hours.
Mm-hmm. But what about the argument that a furlough is just fundamentally different from shortening the work year?
I mean, I don't know that I draw as much of a distinction in that, if you were to furlough an employee for 2 months, aren't you shortening their work year by 2 months? They're not being paid, they're not working those days.
Okay.
And the other thing I'd like to point out is, this is not a case like the New Bedford case or the School Committee of Newton case where the district is relying on its management rights clause alone, where the employers did in those cases to take the action they did. Here we're looking at the language of Article 5 as giving the authority to district, to allow the district to modify the schedule. The language I would suggest in Article 5, it doesn't contemplate a delay for any sort of bargaining. It only requires the district to give 30 days notice in terms of the schedule, or in the work year part, as it did here, reasonable notice. But even if the court were to reject the waiver of contract argument, there is a different path as to why the district should prevail here. The decision to close the building on Fridays is a level of services decision, which is squarely within the district's managerial prerogative. That's explained in the New Bedford case as well, where I believe they closed City Hall at noon on Fridays. But here, really, the evidence in the record.
Your argument, right, their response is that while it may be a level of service decision, the means and the methods of implementing it are bargainable principles or questions, no? Like, and to
The
put more
board-
simply, I suppose, you can do it, but how you do it, you have to bargain for.
Well, Your Honor, I read the board's conclusion is that imputing a decisional bargaining obligation to the district in terms of the decision itself, which the district's position is that's an error of law. Certainly that's discussed in a number of cases where an employer has the managerial right to determine the level of services that it provides. And not only is that apparent in the case law, but that's also in the district's management right clause in Article 2. It says, the words are, it says, the district has the authority to lay off employees in times where continuation of work would have been, less economical or less efficient, but, that includes the ability to furlough employees or shorten their hours. And so here, the record suggests that really the union rejected that proposal. If you look at page 9, the board's decision, the union's position was that, after the meeting between the parties on June 18th, is that, the parties should continue to work 4 10-hour days, and the employees shouldn't have to use any benefited time at all. But, that doesn't address the impacts or the means of the decision. It goes to the district's decision itself, which, that's not the union's prerogative.
So SERB made a finding that there wasn't an impasse. Aren't we obligated to give it some deference on that determination?
I'd agree, Your Honor, that the board is entitled to deference, but particularly as to the impasse part of it, what I would point out, Your Honor, is that, particularly as it relates to the district's managerial prerogative, is that if the district determines that it's going to close the building on Fridays as its level of services decision, the union cannot just categorically reject that decision.
It has to come back with a counter? Is that what, does it have to make a counter proposal or some kind of effort at compromise? Or I've been trying to, what did the union have to do that it didn't do, in your view?
In terms of the impasse or just?
Yeah, and getting to an impasse.
I think the parties arrived at impasse, Your Honor, is that, there was a discussion as apparent in the board's decision as well as the record, in that the union objected to, or first the union objected to, the fact that the work hours should be reduced in the first place to go on this modified schedule. But then there was some discussion about the notice period, which the district agreed to.
Didn't they counter-propose, yeah, we'll do the 10 hours Monday through Thursday, but we don't need to take our personal vacation time or take unpaid leave, kind of like we did the last several summers? Is that, it's not really a counter-proposal, is that your position?
Right, but what's distinct about, what I describe the past summers is more of kind of a compressed work schedule. Here, the whole rationale for doing this in the first place was that there was not enough work due to the pandemic. And so that this was offered as a way to, keep everyone whole and save money, during this uncertain situation. So in terms, in Justice Toone, just to circle back to your question about impasse, what I would say is, when the key factual distinction I think that is perhaps missing or overlooked here from the board is that, the district responded to the union's concerns about delaying the implementation date to the 13th, moving it back 30 days. And then there was the issue of whether employees would be required to use their benefited time. The district had always maintained that employees would have the choice whether they wanted to use a vacation day or personal day or take the Friday unpaid. And the district responded to those concerns by the union, but then the union, that's kind of where the conversation stopped, and then the union sought relief from the Department of Labor Relations by filing the prohibited practice charge. So
First, but what about when they say, and I'm paraphrasing, but just found my notes on this.
What did they
that we don't anticipate any change in hours until we complete our impact bargaining, until we bargain. Isn't that reaching out and saying, okay, we need to talk more about this? Isn't that just what
And
they're trying to do? And then if they don't get and the response is nothing, no response.
I believe we did.
Pardon me?
I believe the district did respond, Justice
That was
Brennan.
on June 24th, according to my notes. And then, again, at least as a finding that was made, there was no further contact, until they filed their June 29th prohibited practices petition. No? Am I missing,
On the
what am I
29th.
missing in there? So I have June 23rd, union disagrees with the portions, including the requirements that they take their time. Why are you mixing up summer hours with furlough? And the effective date isn't really 30 days, given the timing. And then the following day, the union notifies the district, we don't anticipate any change in hours until we complete our bargaining. And there's no response.
But I guess the union is, in a sense, conflating the obligation to impact bargaining with the district's decision to even to close the school on Fridays in the first place. But what is there to impact bargain about where the district has already responded to both of the union's concerns, as Attorney Norris did to Ms. Markland? There were no other counter proposals from the union at that point. The record shows that Attorney Norris invited the union to comment on the MOU, and that was their opportunity, to submit a counter proposal.
It just seems like this issue of union-employer relationships is a kind of complex relationship, and when parties come to impasse and when they don't, it's a very difficult decision, and I'm not sure we as a court are better suited to kind of make an impasse determination than the board that's charged with overseeing this. I guess, how do we get out of the deference to SERB that we would normally provide in this circumstance when it comes to the impasse issue?
When it comes to the impasse issue, Your Honor, I would ask the court to focus on the fact that, as of the 29th, the union sought relief from the DLR. Basically, that's conveying to the district that, the union is unwilling to sit down and bargain further with us, to resolve this issue. So at that point, the district reasonably could have believed that the parties were at impasse, because again, if the union is saying that you shouldn't do this in the first place, well, that's within the district's managerial prerogative, right? I mean, there's a difference between that and bargaining the impacts of a decision, which, and I see my time is going over. I just wanted to conclude, again, the parties bargained for contract gives the district the authority to do what it did here. Now,
Thank you. Your time's up. Thank you.
Thank you.
Good afternoon, Your Honor. Lon Canty on behalf of the Commonwealth Employment Relations Board. As you just went over, there are 3 issues in this case: whether or not the parties reached an impasse, whether or not the union waived its right to bargain by contract, and whether the union waived its right to bargain by inaction. I'll deal with the impasse argument first, since that was where you had left off. First, there's no evidence in the record that the employer knew that the charge was filed on the 29th, such that that would be a factor at all as to whether or not there was an impasse.
Had the employer known, would that have been a factor?
No, the board does not believe that should be a factor. The charge indicated that the union believed that the district had already made a decision by the time that they filed a charge. That wasn't the issue before the board, because then the district implemented after the charge was filed. So really what the issue has nothing to do with the prohibited practice charge. It really has to do with those final days of discussions in the emails and the implementation on the 30th of June and the follow-up amendment on July 1st.
Did the union have some obligation to make a counterproposal to sort of meet Essex Tech partway? I mean, what's your understanding? I'm just trying to understand sort of what's the rule on arriving impasse. Is it is it enough for the employer to say, oh, we're going to do this, and the union to say no? What has to happen? What's required that there not be an impasse here?
Yes, so there must be notice and an opportunity to bargain. And if the union simply decided not to respond to the notice, that would be considered waiver by inaction. They didn't do that. What they just did was respond and say, we'd like to bargain. And they repeatedly said, we have these issues. We had concerns about using the leave. We had concerns about the effective date of the furloughs. And then mixing in other furloughs that were discussed in May discussions.
At what point does it become clear, though, if the district says, well, I mean, this is our position, here's where we are. You take your vacation time, you take your sick time, or you take a day off. And that's pretty much what they said, right? I guess to Justice Toone's question, how do we know when there's an impasse or not an impasse? Because if we have two positions that are clearly stated in our somewhat, I'm not going to say they're diametrically opposed, but they're on critical issues.
Yes, so impasse and when that happens is a question of fact that is very fact intensive, and as such, it deserves deference. The board's determination deserves deference. So with that said, there must be...
What it looks like. What should it look like?
Yeah, so what it looks like is when there's no room for movement from the parties, and that's clear on the record. Here, the union was discussing, I'll use a clear example here, the union was discussing a July 13th implementation date because they received a notice from the district on June 13th of this proposed plan regarding closing Fridays.
So maybe I'm stating the obvious, but you're saying, so for example, they could have said, okay, we can go along with that, but not for 2 months, we'll do it for a month, or somewhere along those lines, is that, or just the implementation, instead of beginning of June, mid-July, and that has less of an impact?
Correct, correct.
Okay.
And so that was one of the issues. The district had responded that they would move the implementation date, but they responded, we'll do July 10th instead of what the union had said it believed it was its implementation date. So that still had to be worked out. And then despite the MOA saying, proposed MOA, I should say, saying June 10th, the actual implementation was then, July, mixing up my July and June's. Despite the MOA saying July 10th, the actual implementation was then July 13th. And then the date to which it moved to was also, I don't recall the exact date, but say the MOA said August 12th. It was actually August 24th that it was implemented. So there were still issues to be discussed. And the union sought to discuss these issues. And there was clearly no impasse. So I want to address the waiver by contract issue as well and make clear that the burden is on the district to meet this affirmative defense. It has to be clear and unmistakable that the contract allows the district to do this. And if it's not clear and unmistakable, if it's ambiguous and there's more than one interpretation, there is a way for the district to then say that the contract allows them to do this, which is by providing bargaining history. That's not what happened here.
By providing bargaining, I'm sorry, what did you say? I didn't hear what you said. By providing bargaining?
Bargaining history, yes.
History, okay.
So to the extent that they argue that, well, the language regarding the year, shortening or lengthening the year, that's one, the board is not saying that is what that is the only thing the contract allowed the district to do. It's merely saying there's more than one interpretation, and therefore it's not clear and unmistakable waiver. There was no bargaining history on that contract language, and therefore the district did not meet its burden of proving that there was a waiver by contract.
So Essex Tech could have asserted this position. We read the work year provision in Article 5 to justify a furlough. They could have asserted that, but then there'd have to be bargaining that followed, and they made that unilaterally instead of allowing for that bargaining to take place? Is that?
No. So the bargaining history that I'm referring to is when that contract language was agreed to by the parties.
Okay, history leading up to the adoption. Okay,
Yes,
sort of.
yes.
Oh, so you're saying it's sort of like legislative history for Article 5, and they could have pointed to that and said this was included in that.
Correct.
I see. Okay.
So, because oftentimes contract language is ambiguous, and so the waiver by contract standard does provide the district an opportunity to provide bargaining history to clear up what that ambiguity is, to assert that they did affirmatively waive their right to bargain over.
What would that have looked like, bargaining history, sort of discussions and them saying, oh, by the way, when we put different work years, we mean also furloughs or something like that?
Yes, that this was an issue they specifically contemplated.
Okay.
I believe my time is up with the red blinking light.
It is.
If there are no further questions, thank you.
Good afternoon, Your Honors. May it please the Court, my name is Justin Murphy, representing AFSCME Council 93, the American Federation of State, County, Municipal Employees. It's much faster to say AFSCME.
Well done.
And while I am here requesting that this Honorable Court affirm the Commonwealth Employment Relation Board's decision, I would like to provide some context into the union's perspective as to what occurred based on the record. You have this decision in early May of 2020 where the district was contemplating some budget cuts. Again, nothing determinative. We're still waiting for approval on funding. The union is just hanging on and waiting. On May 21st, we have a budget with three possibilities: Plan A, Plan B, and Plan C. Plan A, obviously containing for a three-day furlough for some members, a summer furlough for some other members, hiring freezes, and a pay freeze instead of a furlough. And funny enough, this all got changed in June of 2020 when they finally proposed the fact that we're just going to have you work from Monday to Thursday, Fridays off. You can take it unpaid. That's completely different. So from May to June, the union's kind of wondering what's going on here. We're not understanding what's going on. We're getting little tidbits of plans, no final approval, no actual authority to make this a proposal. And yet, it's not till June 15th, 2 days later, where our staff actually says, can we actually bargain over this, please? And we have a meeting, a Zoom meeting, on June 18th, where the district has an official position, Monday through Thursday, 8-hour shifts, Fridays off. We counter, referencing the previous past practice from 2017, 18, and 19, respectively, where the members worked 10-hour shifts or had the ability not to or take it unpaid.
Real-world impact here is the folks are out about a week's worth of pay, right?
99 days, to be exact.
99 days, wow, okay.
99 collectively over the summer through all the members. I believe there were 13 or 14. 99 days in question here, in which the members kind of had to either use their own time or take unpaid. And so at that point, after this Zoom session, there's a follow-up email from our staff with the district's counsel. He sends over a memorandum of understanding introducing furloughs again, which was not previously communicated. And yet, again, we're caught by surprise. Our staff agent specifically says, we are not in agreement. Why are you mixing this up? Also, we're trying to kind of get more time so we can understand this. You haven't even given us a 30-day notice. So while council does respond saying, oh, sorry, I don't think it's unfair, you're holding the superintendent's feet to the fire, that's not necessarily a counteroffer. That's just, well, come on, you're being unreasonable, take the deal. That's not necessarily fair. And so we say the next day, we were expecting a call from you. No one decided to pick up the phone. And so to say that we were at an understanding and had this bargaining history, we were caught completely by surprise, kind of dealing with what the district decided to do. You've heard mentioned that the district believes that it had the right under Article 5 of the parties' agreement, but Article 5 specifically speaks to workday and work year. Workday, which we argued at the hearing and provided evidence, was a change in shift. I had the local member testify at this that between 7 to 3, of course they could change it to 6 to 2. That's fine, you have the right. It's expressed in there. Work year, shortening the days of work for the school employees. Again, there's nothing in there that says that you can reduce the number of hours. So to say that they had the right, but if they didn't, the zipper clause would take care of it, is just trying to...
Just on the work year provision, they could reduce overall hours by shortening the work year.
Based on my reading of it, Your Honor, I believe that they couldn't reduce the hours. I believe, while that might be the effect, I believe that member would be paid, or at least we would demand to bargain over this impact to the member. If they're losing hours, suppose they work 40 hours a week for 10 months, and it's known that that position is a school year position. That's one thing, but if you're going from, it's not just that position, it was the whole bargaining unit. So I think they tried to take an ambiguity in the contract and try and suit it for themselves based on the circumstances that were happening in this.
Okay, so you're saying that it's not necessarily in Article 5 any provision that allows them to reduce total hours under any circumstances?
No, and I recognize that the district has the right, based on its budget cuts, to do its level of service decisions when it decides to open, when it decides to close. But as this New Bedford case stated, the means of implementing that decision is bargainable, which I would state to before resolution or impasse, before implementing. That decision, as it affects employees.
Can you give me an example of the means,
Furloughs. As the court said, furloughs is not the only means of implementing that decision. Making members take time, utilize their own accrued time to fit the district's purposes. Again, not. We have seen that.
Isn't that what they were doing here or trying to do?
Correct.
Okay.
Which is against the precedent and previous past practice of the 2017, 18, and 19, where our members worked 40 hours. They worked 10-hour days Monday through Thursday.
I'm sorry. You're saying that is bargainable. That's not their prerogative.
Correct. It is bargainable. Well, it might be their prerogative. I'm not trying to sit here and say that I know better than the district on how to run its affairs. But as it relates to bargaining unit members and the impacts to them, you have to bargain with us over. And there's no concern here. The case law is clear. The person implementing the change is obligated to bargain to resolution or impasse. We only had one session where there was clearly a miscommunication. They wanted to have Fridays off. We wanted to go back to our old style of the previous past practice. Then furloughs came into it. Where did that come from? So there's a lot of confusion. To say that there was that impasse would assume that the parties were deadlocked and that further bargaining would be useless. The definition of impasse is exactly that. But we said we don't anticipate any changes until we complete impact bargaining. You haven't picked up the phone. We've only had one session. We don't think you're just going to implement. But that's exactly what happened. Because when we brought up the concerns, the only thing the district's council decided to do was change the day. He didn't address the issue of furloughs, and he didn't even talk about scheduling a new day to bargain. And I'm not trying to place blame on anyone, but clearly the miscommunication and the artificial short time frame here, there was an obligation to bargain before implementing, and it should have been done well in advance to allow enough time for this, so no one was crunched up against the clock.
Do you agree that the board receives deference on its determination whether or not there is an impasse?
Yes.
Even if it were determined that there was an impasse in certain circumstances, it would get deference for that?
Correct. In the Commonwealth Employment Relations Board's infinite expertise on the subject, I believe they are given considerable deference on questions of fact, specifically with impasse. In this situation, I think it's imperative to note that after we filed the charge, the district amended its position 2 more times. How could you be at impasse if you further compromised? 2 more times. And so for these reasons, I would ask this honorable court to affirm the board's decision. There is no error of law. There was careful scrutiny based on the expertise they possess. Thank you.
Thank you. That concludes today's session. I want to thank everybody who helped today, particularly Officer Spady and Officer Montgomery, and Attorney Ling, our timekeeper, so that we are now stand in recess.